Justice of the Division 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court will give their attendance and they shall be heard.
Welcome and good morning. The first case for oral argument is People versus Jones, 995.
Good morning, Your Honors, and may it please the court, Peter Banishak for Mr. Ronald Jones. Unless the court has any questions with respect to the appeal waiver, I'd like to go.
I actually do, Mr. Banishak. Good morning.
Good morning.
You're familiar with People versus Thomas, of course.
Yes.
Do you have the sense at all, based on the work that you do, and I'd have the same question for the DA, is Thomas sinking through to the trial courts at all yet? Has it kind of made its way through such that the language of Thomas is being appreciated, et cetera, on the appeal waivers? What's your sense, if you have one?
Judge, it's difficult for me to say with respect to cases that have occurred after Thomas, just because those haven't yet reached the perfection stage. But I think it may vary, but I'd have to assume that judges got the message.
Fair enough. Thank you.
With respect to point two, if this court were to advise an attorney that he had the right to either be present for an argument or appear virtually, and that lawyer stated, I would feel more comfortable appearing virtually, it would almost certainly be understood that that lawyer did in fact want to appear virtually.
But wouldn't it be the same if the lawyer said, I think I want to appear in court rather than virtually? And we've held, many courts have held, I think I might need a lawyer is not unequivocal.
I think the statement here is more assertive than I think.
Okay, so the statement here is I would be more comfortable if I had a lawyer.
It was, and I think there's a few things that I'd like to note that I think are important. One is that statement was in direct response to, with these rights in mind, are you willing to talk to me?
But counsel, even after that statement was made, the officer really kind of backed off and said, well, here, think about it now. You know, if you want a lawyer, I'll go over your rights with you again. Need some time to think about it. I mean, the officer, I think, really took his time and left the door open with him. Look, if you ever want to stop, just tell me and we'll stop. I mean, how would you respond to that?
Judge, our position is that the key point in time that the court has to look at is when the invocation was made. And I think both us and the respondent cite People v. Glover, and that case states that you look at the suspect's demeanor, the manner of expression, and the particular words used. I think the analysis has to stop there, because if we look at what the officer did and how the officer understood the suspect's statements, we're looking at the subjective understanding of that officer. In addition, we would allow officers, or we would allow police to essentially muddy the waters or get a suspect to backtrack almost no matter what he initially said. It's possible that Mr. Jones could have said something, you know, I want an attorney before I speak to you, or you know, something along those lines. The officers still could have asked the same questions and obtained a waiver nevertheless. And I think that that's the danger, that if we go down that road of looking at what the police did in response, I think the analysis has to stop with what did the suspect say.
Right, but here the officer could have, it's a little ambiguous as to what the guy meant, because he said, I would feel more comfortable if I had a lawyer, right when the officer was advising him of the Miranda rights. I think the way the officer took it, it sounds like, is he might not have understood the rights. He might be more comfortable if a lawyer told him the rights. So the officer slowed down and repeated them. And isn't that one interpretation of what happened?
Judge, I have to respectfully disagree, because the Detective Ferry asked Mr. Jones two questions. He asked him, do you understand these rights? And Mr. Jones said yes. So I don't think the record allows for the possibility that he somehow didn't understand his rights. It's only when he asked the second question, are you willing to talk to me, did Mr. Jones say, I would feel more comfortable if I had a lawyer. So I think his response is directly responsive to that question, not to whether he understood his rights. And I think under those circumstances, this court should find that the response was an unequivocal invocation of the right to counsel. With respect to point 2, we acknowledge that in order for this court to reach this issue, it would have to reconsider case law that says that orders denying a challenge to a DNA swab are forfeited by a guilty plea. We would, however, urge this court to find, as the third department did in People v. Rochester, that this issue survives a guilty plea because it's effectively a suppression issue that's encompassed by CPL 71070 subsection.
You're asking us to disavow People versus King, decided, I think, a couple of years after the third department case.
That's true. I believe King was 2017 and Rocha was 2015. I would make a couple points though. One is even the respondent's brief acknowledges that the request for a DNA swab is more akin to a search warrant rather than a discovery request. Secondly, if this issue is forfeited, it creates an inconsistent result between the same issue that arises pre-indictment. So if a judge issues an order granting a DNA swab pre-indictment, a defendant would move to suppress it post-indictment, and it would be reviewable on appeal.
Have you seen, I couldn't find any, but there's one third department case that you cited that doesn't agree with us, although it might be a little different factually. But what about the first and second? This issue must have come up in there are many thousands of cases. I didn't see any of them going your way on it.
Judge, I don't believe we found any cases in the first or second department. I can't say that there definitely aren't any, but I don't recall in my research coming across those. And there certainly isn't a court of appeals case that's directly on point. I think even in King, this court cited People v. Hansen, which involved the question about a grand jury defect issue. The last point I'd like to make on this issue is that not only are there Fourth Amendment interests implicated here, but I think there are also speedy trial interests implicated by the fact that this was a late motion unsupported by good cause. Necessarily.
Let me stop you there for a moment. I think now defense counsel did orally say, gee, this seems kind of late. I think I'll acknowledge that, but he never argued that the people failed to articulate good cause for the late application. So I don't know that good cause argument is preserved for us, is it?
Judge, I think the argument that it was late is an argument that it was beyond the 45-day period. So that's preserved. And then I think the burden shifted to the prosecution to establish good cause. And while the prosecutor made some arguments on the record, we cite People v. Barnes in our reply brief, which stands for the proposition that to establish good cause, you have to make sworn allegations in your moving papers. Arguments made on unsworn arguments made on the record are insufficient. And moreover, the prosecutor's arguments were that, Mr. Jones at later court appearances said that he wasn't there, he didn't commit this crime, which I don't think is materially indistinguishable.
Right, look, it was obvious they needed this evidence. The defendant pleaded not guilty. So I agree with you if the issue is not forfeited by a plea and if it's properly before us, if there was an objection. I agree with you on the good cause aspect, but you got a lot of hurdles to get over before you get there.
I agree. And that, two more seconds. The last point I wanted to make with respect to speedy trial interest is that this case seems to really occur at the intersection of the Fourth Amendment and speedy trial concerns. And because both Fourth Amendment suppression issues and speedy trial issues survive guilty pleas, an issue that occurs at the intersection of those issues should likewise survive a guilty plea. Thank you.
Thank you.
Good morning, Your Honors. Brad Osler for the people. May it please the court. I'll address Justice Kern's question first regarding the appeal waiver. I don't believe I could speak intelligently as to whether or not the courts, at least in our county, are heeding or have taken into account Thomas. The only thing I could say with respect to this particular appeal waiver or waiver of the right to appeal was that the court separated the rights that are automatically waived with those that are not. And I think in this case, very specifically delineated that the review of the sentence was going to be foreclosed certainly by the waiver that was signed.
Didn't we hold in People versus Brown that it was inadequate?
I think there is a certain similarity here, Judge. I can't deny that, but I think the overall colloquy that was involved, at least in this case, was relatively detailed with respect to the fact that this was required as part of the plea and was covering the sentence and certainly delineated the different rights to at least to an extent. Moving to the invocation of the right to counsel, I would submit that, as we did in our brief, that the statement by the defendant that I think I would feel more comfortable with an attorney on its own is not an unequivocal statement. And I think it's important here to note that immediately afterwards, the detective that was interviewing the defendant did not pressure or coerce or sort of unduly hound the defendant to try to talk. He said, well, I'll read them again. Do you want some time alone? I'll leave the room. Would you like to, do you want a phone by? I mean, he offered some alternatives to enable the defendant to make an unpressured decision. And in fact, to unequivocally invoke his right. And the defendant not only did not do that, but immediately sort of indicated that he would sort of keep that in mind. He said something along the lines of the fact that if he got uncomfortable, my reading of the words that the defendant said, if he got uncomfortable, he would keep in mind that he was entitled to an attorney.
Right, and by saying he would feel more comfortable if he had an attorney, doesn't mean that he would be uncomfortable without one.
I think that's true, and I think his sort of immediate willingness to start talking is pretty clearly indicative of that. And that's the sort of totality of the circumstances here that this court is certainly entitled to review. And I think in this case speaks to our favor. The defendant was advised and chose to waive that right. I'll move on to the order to show cause for the DNA swab.
Counsel, I didn't see an order to show cause in the record.
It doesn't appear that one was.
There was an affidavit, but there was no order to show cause.
Correct, and I don't know if maybe it was that the court or the parties involved felt that it wasn't necessary and they were going to essentially stipulate.
There clearly was an application.
Right, but I think that the court's not wrong that this is a matter that's not so much akin to a discovery request right after the start of a case, so much as it's more similar to a warrant application where we would normally provide some level of detail that would substantiate the request. Now, in that respect, it's important because this would not be subject to the 45-day time limit, and I think in this particular case, it actually works to the defendant's favor, or generally speaking, to a criminal defendant's favor, to not have this intrusion on their person sort of, as a matter of policy right at the start of a case, even if there's no expectation that there may be a need for DNA. If the people made this application, once they realize that, look, there may be some actual probative evidentiary value to a DNA swab.
Did I hear you say this correctly, that in the alternative, they could get a warrant outside the 45 days under the statute?
I don't necessarily mean that they could, but I think the process, the order to show cause process, is more akin to a warrant application because we would be obligated to provide some level of detail substantiating our request. So to that respect, it's not so much it's not parallel to sort of a discovery request that would be governed then by 240, now by 245, but it's sort of an outside proceeding. We have to have some level of basis to substantiate the claim. And I think that works to all defendants' favor because it means that it's not going to just become an automatic part of discovery.
I think you're saying you only ask for the swab only once you realize plea bargaining discussions were not going to be productive. And only then did you ask for this intrusion.
Right, that's certainly part of the calculation. In any event, I would just lastly comment briefly on the Rochester case. It's not exactly clear to me why the third department came to the conclusion it did. It's the language of that decision suggests that it was the order to show cause or the swab was being reviewed in the context of a review of a suppression decision, that this is not a procedure that normally would fall under that. I don't know if maybe there was some procedural aspect of that case that was perhaps different than this one. But in any event, I would, to a certain extent, I would respectfully submit that the case might have been decided in error, at least with respect to that particular point. I don't think this is subject to review under 71070. And in that respect, review of this has been waived by the entry of a guilty plea. Unless there's any further questions, all right.
Thank you.
Thank you.
996, People versus Clark. Good morning.
Good morning. May it please the court. Carolyn Walther for Delbert Clark.
I would get right into the merits of your argument. I don't think you need to spend any time on the waiver.
Thank you. If I may, I'd actually like to start with the ineffective assistance of counsel
Sure.
portion of my argument, which is point 3 in the brief. And here, counsel's failure to make a motion to suppress the weapon was not a matter of strategy, primarily because this issue would have been dispositive of the entire case.
If it would have been dispositive if the defendant prevailed.
Well, yes.
So it comes down to the defendant doesn't have a driver's license. He's asked to step out of the motor vehicle, step around to the back so they don't get hit by oncoming traffic. He takes off. Is that correct factual recitation? Then while he's running, he drops the gun?
I think that's fair to say, although because counsel failed to make the motion to suppress the weapon, we really don't have as fulsome of a record as we might otherwise on that issue. We don't, for example, know what the substance of the conversation was between the officer and Mr. Clark.
Okay, but under those facts, it was lawful to ask him to step out,
Yes.
and the guy runs and drops the gun. If that's what happened, then the pursuit was lawful and there'd be no suppression of the gun. If those facts are correct. You're saying there might possibly be other facts we don't know about if there had been a motion and we should speculate that maybe something else happened.
Well, I don't think this court needs to speculate or even find that something else happened, but I do think that there is a colorable argument that suppression would have been warranted and that this case would have been analogous to People versus Hightower decided by this court where, again, the initial stop was lawful, the request to step out was lawful, but the police actions, including the questioning and the pursuit, escalated it beyond what was lawful, and so the physical evidence was the fruit of that.
But we don't know, under Mendoza, we're not sure. Maybe the lawyer wanted to and talked to the client and they couldn't get enough facts together to put in an affidavit. They didn't. So that would be more of a 440 application.
We don't believe that a 440 application would be required. We do believe there is enough on this record for the court to determine that given this factual circumstance, this would not have been a matter of strategy and is ineffective assistance. Moving on to the other primary issue that undermines the validity of the plea here. We would submit that the court's suppression ruling was error, that the identification here lacked the reliability needed in order to be admissible. And specifically, a few of those factors undermining the reliability of the identification here included that the police officer went to the scene on his own after hearing over the radio that his fellow officers had detained a suspect there. He only had the opportunity to briefly observe Mr. Clark during the initial traffic stop. And he testified that the person he identified looked different than the person that he had initially stopped.
Yeah, this guy must have got a quick shave and a haircut. Right.
That's what the officer testified. I don't believe there was any other evidence presented on that point. And so for those reasons, we would submit that the court suppression ruling was error and undermines the validity of the plea.
Thank you.
Thank you.
Counselor?
Lisa Gray for the people. Good morning, Your Honors. Just briefly with respect to the ineffective assistance of counsel claim, it's clear from the record that the defense attorney in this case certainly had a strategy. He focused his efforts in suppressing the identification and not seeking suppression of either the physical evidence in this case, which he would have had to assert standing. So clearly the attorney had strategy with respect to how he approached the suppression motions. And just moving towards the suppression hearing, in this case, the police officer testified that as an 18-year veteran, he certainly was trained and in his experience knew that it was important to make note of physical characteristics and details. Certainly at a roadside traffic stop, it's probably one of the most dangerous aspects of a patrol officer's job. The interaction with Mr. Clark lasted about 5 or so minutes, I think, a couple of minutes with the conversation. He had an unobstructed view. It was daylight in the afternoon. And then he also had a second encounter with Mr. Clark outside the car, which lasted anywhere from 30 to 45 seconds. Clearly, those factors all go to, and as the trial court noted, those are the factors that he took into account when finding that this was a constitutionally permissible identification procedure. Unless there are any questions, I would rest on the brief. Thank you.
Thank you. 997, People versus Moore. We all set? We can't hear you, Mr. Kemp. Looks like you've got to do something with your mic, your sound. Still can't hear you. Okay,
Your Honors.
I think we're rolling now.
Okay.
You can proceed.
Your Honors. Robert Kemp on behalf of the appellant.
I
Robert.
can't see you so good though. Maybe you can adjust your camera.
Sorry.
Okay, we're good.
Okay, I'm sorry. It's a webcam connected to a desktop. I'm sorry.
No, we understand. These are difficult times. You can proceed.
Okay, may it please the court. Today, I'd like to focus on point 1 of the brief, and I realize that point 1 relates to the conviction under count 1 of the indictment, criminal possession of a controlled substance in the 3rd degree. But what's important here is this turned into a blanket or exploratory search which exceeded the scope of the search warrant. As this court knows, a valid search warrant must.
Mr. Kemp, can you hear me?
Yes, I can.
It's over here. Your brief seems to attack or address a search of the attic.
That's correct.
You say that a number of times, but they hadn't actually reached the attic when they found the drugs, correct? They were on the stairs leading to the attic, correct?
Well, the issue here is that there was a doorway. Both Buffalo police officer Sean Adams testified that there was a doorway, but he doesn't recall if there was a door there.
Put the doorway aside.
Okay.
I thought the drugs were found on the stairs leading to the attic, not in the attic, correct?
Yeah, but there was on the other side of the door frame that leads to the attic. So there was a door frame there. And the question is whether there was a door blocking the attic area. So that's the issue here, whether there was a door there.
You know, we understand it. Let me just interject. I don't mean to, I'll let you take over from here. But the door that, we'll get to whether there was a door attached or not, or whether it was busted in. But the door was on the same level as the second floor apartment. In other words, it was on that same landing.
That's correct.
Okay, so then from that point, then I guess whether there was a door or no door, there would be a few stairs, and then you would enter the attic?
No, the door frame separates the stairs from the landing. So the door frame is actually, there's a door frame and then there's stairs leading up to the attic.
Right, and then you get to the attic after the stairs.
Correct.
Okay, okay. So the real issue, I guess, and I'll let Judge Curran take over, is whether there was a door there
Correct.
and whether there were locks on that door.
That's correct.
Okay.
David Moore testified that he was there. I mean, he was remodeling the house. He works at the mechanic garage, and he said that there was a door there. Now, we all live in Western New York or Central New York, and we know that this time of the year, when this event occurred.
Mr. Kemp, let me interrupt you again. The question is whether or not, that you want us to answer, is whether this was a search that went outside the scope of the warrant authorizing a search of the common area, correct?
That's correct.
And so now we have to decide whether or not there's sufficient evidence that this was a common area, the stairs leading to the attic. Is that correct?
That's correct.
All right. Now do you agree that the stairs leading up to the first level apartment is a common area?
Yes, I do.
How about from the first apartment to the second apartment? Is that a common area?
Yes, I do. I agree.
Why do you say that the stairs leading to the attic ceased being an extension of that common area?
Because there was a door there. Before you got to the stairs leading up to the attic, there was a doorway. And the question is whether the door was breached there. The door was before the stairs leading up to the attic.
Right, but let me back up a second.
Whether that door was breached.
Let me back up. You just conceded that the stairs leading, the back stairs we're talking about, leading from the first floor apartment to the second floor apartment was common area.
Yes, I do. I concede that.
How do you know that?
Well,
common
testimony
area
that the stairs lead both up to the first apartment and the stairs go up to the second apartment. Now,
Well, there's a set of stairs. There's a door that leads outside,
yes,
and then there's the interior door that leads to the first floor apartment. Then there's stairs that go up to the second floor apartment.
yes.
How do you know that that's a common area? Common area is defined, if I'm not mistaken, as an area where both tenants have equal access. Wouldn't we need to know, first of all, there were no tenants in this apartment upstairs or downstairs, but wouldn't we need to know the terms of the agreement between the landlord and the tenants, or the tenants between themselves, to know if the first floor tenant had rights to go up those stairs?
Well, I don't know that. I don't know if the first, the tenant that.
Right, you have no idea. We have no idea. There was no lease agreement admitted into evidence. The landlord wasn't called. None of the tenants were called because there were no tenants. So you don't know if that's a common area, and that actually helps your case. Because
that's true.
The people have the burden of proof, I would think, of proving a common area. We have no idea who, if there were tenants, hypothetical tenants, who would have access to the attic, who would have access to the stairs leading to the attic. We have no idea. So isn't that a failure of proof by the district attorney?
Yes, I would say so. I'm sorry. I was just focusing on the attic because obviously there must have been a door there.
Right.
As I began to say, and it's stated in my brief, this was in January. It would be absurd not to have a door from an open stairwell leading into an attic area where warm air would just go out into the.
Is it your position that this record did reflect that not only there was a door, but also that there were locks on that door?
That's what David Moore testified, that there was a padlock.
What
on
are
the
we-
door and he didn't
what
have
are we
access
to
to
do?
it.
How are we supposed to handle the fact that the trial court, I guess they found your client to be not credible?
Well, I guess that's an issue of credibility because the Buffalo police officer testified that he saw a door frame, but he could not recall if there was a door there.
Mr. Kemp, so presumably there's a door to the outside that they entered, right?
Yes.
And they then went into the common area. Just because there's a door between common areas does not mean they can't go through the door. Your argument rests on the idea that it has to be locked, correct?
Yeah, not only that the door to the attic was locked, but this was not included. This was not specified in the warrant. It said, lower apartment, upper apartment, and the garage area. It did not specify the.
Right,
It said common area.
It said common areas, and you place, I think, a lot of emphasis on the fact that it was locked. Your client did. He testified it was locked, double locked.
Yeah, locked, and it was.
Even though we know the drugs with his DNA were found on the other side of that door, but that came later, so we can't consider that. But I don't think locks makes any difference because the tenants could have keys to the locks.
That's true, but there was a door there, and also it wasn't described in the warrant. That was.
But Mr. Kemp, don't you have to show, or don't we have to conclude that the door was locked in order to conclude that the common area ceased at that locked door? Because otherwise, wouldn't the police be able to continue through a common area and open doors leading from one common area to the next, correct?
Well,
It has to be locked.
once again, that was not described in the warrant. There was a 2.5-story structure described in the warrant, and the attic was testified by the Buffalo police officer that was the half-story is the attic. So that was not in the warrant and should not.
I think we've got your arguments.
Pardon?
I think we got it. Is there anything else?
No, thank you, Your Honors.
Okay, thanks.
Good morning, Your Honors. I'm Matthew Powers on behalf of the people. I agree with Mr. Kemp regarding the physical layout of the structure. There's no disagreement there.
How are we supposed to know whether this is a common area without a lease or any testimony from the landlord or any testimony? I know there were no tenants from tenants. In other words, we can let our minds wander about usually with a two-family house, what you're entitled to use or not use, but that's really not our place to do that. So whether there was a door or no door, don't you need to put some proof in that establishes that this is a common area? And could you tell us where that was on this record?
Your Honor, there was no lease agreement or anything like that. I freely acknowledge that. I was kind of surprised when I was researching this issue how few cases I found.
Whose burden is it to establish that this area was a common area?
Well, the people have the burden of going forward, Your Honor.
Correct.
The defendant has the ultimate burden of showing the illegality, but we have the initial burden.
So in response to Justice Carney's question, you have the burden to show it's a common area. What evidence did the people admit at the hearing to establish that it was a common area?
Right. Well, what I was trying to get to, Your Honor, was of the cases that I did review that deal with common areas, attics, basements like that, it doesn't appear that any of them, at least not from the text of the decisions of the appellate divisions, that any of them include evidence of lease agreements or something like that. They all revolve around evidence of the physical description of the layout of the structure. And I don't really think any of them go any farther than that. Here we have a first floor unit, a second floor unit, and an attic that are all accessible through a stairwell. Central to the concept of common area is that no individual tenant retains control over that area. And here the physical layout of the building indicates that both the first floor tenant, if there was one, which there isn't, and the second floor tenant would have the exact same amount of access to the attic.
They have the ability to get to that area. It doesn't mean they have the right to get there. Like, a lot of two families.
Sure.
The upstairs tenant has the attic, the downstairs tenant has the basement. Would you say in that situation that the basement is a common area?
I'm sorry, can you repeat the question, Your Honor?
If there's a two-family dwelling and the landlord tells the downstairs tenant, you have the basement for storage, the upstairs tenant has the attic, would you say that either the attic or the basement is a common area?
In that case, I would not, but there was no such understanding of that kind of specific agreement here.
Yeah, I'm just having problems when there's no tenants.
Sure.
Your client wasn't, I'm sorry, not your client, but the defendant wasn't a tenant.
Everybody's my client, Your Honor.
Yeah, there were no tenants here. So can you even have a common area without any tenants? Is that even factually, legally possible?
I would, just based on the cases that I reviewed, Your Honor, they all seem to turn on just the layout of the structure. So if it's accessible to one and accessible to the other, then I would say it's a common area. Maybe the attic would cease to be common if it was locked. But of course, the only evidence of that came from defendant, and we know that the trial court rejected his testimony, I think with fairly good reason. And the other thing I would point out is that in the trial court's decision, it cites to People versus Rauchi, which says that a lawful search is not limited by the possibility that separate acts of opening or entry may be required to complete the search. And that's all that law enforcement was doing here. And the other point I would like to make is that this suppression issue relates exclusively, as we know, to the drugs that were recovered. It does not implicate the gun. I think in my brief, I suggested.
Right, yeah, look, I agree with you on that, but he would be, if he wins on the suppression for the drugs, he pled to the gun, he could vacate his plea to the gun, correct?
That's exactly what I was getting to, Your Honor.
Okay.
I discovered after I wrote the brief, this court's decision in People versus Williams from 2018, defendant was promised concurrent time on the gun and drugs. That being the case, if you were to agree with my opponent regarding the scope of the search, the plea would be invalidated, but the recovery of the gun would not be subject to suppression.
Okay,
Unless there are any questions, I'll stop there.
thank you.
Thank you.
998-999, matter of Jada W.
Good morning, Your Honor. May it please the court, John Sarandon from Syracuse on behalf of the appellant, who's been denominated as the aunt in this matter. This is an appeal from an order dismissing a petition for the aunt's petition for custody and an order freeing the child for adoption. It's undisputed that the aunt was unable to take care of the child.
Yeah, Mr. Serrano, let me ask you this, because I think I understand your argument with this obligation under 1017. So as I understand it, once there's a temporary removal, the court directs the Department of Social Services to do an investigation. And I guess what your argument is that even assuming arguendo that there was some discussion with the aunt, and she indicated that, you know, it was too much for her to handle, that I guess this was somewhat of a continuing obligation for the Department of Social Services to reach out to the aunt. And that ultimately, even though at the ending of the case, when the aunt filed the Article 6 custody proceeding, that the fact that they didn't comply with 1017 shouldn't put your client at a disadvantage, because there was some time, 18 months, 20 some odd months, that this child was with the foster parents. Is that?
Yes, Your Honor.
Because I don't know how we would get to this anyways. I guess if at the time of the 1017, if the court doesn't comply or the county doesn't comply with it, I guess what you could do is try to get permission to appeal that, because otherwise, the placement is always going to be, I guess, work to the disadvantage of a relative that a year or two later seeks out custody, because the foster parents would have the child, and that probably would work to their advantage with the custody proceeding.
It was basically, I think when you look at the record, you see sort of a backstory between that family court judge and DSS insofar as relative placements and foster placements. And the other thing is, once the Texas placement broke down, we submit that DSS had an obligation to go back to the aunt and
Because
just
your
say,
client may have reconsidered at that time because her initial decision was based upon her thoughts that the relative in Texas and ultimately the child might be returned to mom after that.
yeah, two things in regard to that, Your Honor. Yes, and she was taking care of the child's siblings at the time, one of whom was suffering from, I think, drug withdrawal at the time of its birth, and the other sibling, the younger sibling. So, and insofar as return to the mother, I think that's true. That at the time, there was something in the record where the aunt is indicated saying that if she got custody of the child, it would go back. She would want to give it to the mother. That was at a time when the plan was return to family or return to the mother. So we submit that there was an obligation on this record, on these facts, for DSS to come back to the mother or to come back to the aunt and just say, is your position changed because what you thought was going to be a relative placement fell through?
Mr. Sorrento, I mean, how many times does the department have to ask the aunt, though? I mean, they asked her, she said no. How many times they have to go back to her? Or if circumstances change, shouldn't it be incumbent upon her to say something?
Well,
how would the department know?
Here's the aunt's position was obviously, I would take the child, but I'm overwhelmed.
Right.
Okay? So now she's quote, out of the picture, and they have, because another family member is in play.
Right.
When the other family member comes out of play, I think it's incumbent on DSS to say the other family member is out of play, so therefore, are you available? And I think when you look at that Randy NN case that we cited, it's pretty clear that the burden is on, DSS, not on the relative.
It sounds like the aunts changed their mind based on improper reasons with respect to one of the foster parents,
No,
how the foster parent identified him or herself.
no,
That's what it looked like from the record.
no, Your Honor, she did not.
Okay, I think we understand. Is there anything else, Mr.
Can I
Sorrento?
talk about best interest of keeping the siblings together?
Sure.
The only expert testimony on this record was from the psychologist who indicated that the strongest bond the child makes are those of a biological connection, and the sibling relationship is the most lasting relationship. She also indicated that adopted children separated from siblings have more difficulty understanding the concept of family and more difficulty transitioning emotionally into late children and late childhood and early adolescence. We submit that on this record, the trial court, family court, did not adequately consider the fact of what effect it would have on the children, the older children, and the child in question as to the separation of the children. And that we submit that the court never truly determined whether short-term trauma would be more than compensated for by long-term advantages of the siblings being together. And I don't think there was any type of forensic information presented to the court or obtained by the court.
Yeah, no, this was mitigated a bit by the fact that the children have regular contact that was encouraged by both sides. And one of the oldest child, I believe, is 15, probably is not going to be in the household that much longer. But it's not as though, and I agree, when I read that, I said, you know, my first instinct was all the three should be together. But it was comforting to see that they have visitation, regular, persistent visitation. They won't be strangers to each other.
And that leads me into my final point, Your Honor. Thank you.
Welcome.
The record is replete with indications that the foster parents indicate that they would ensure contact between the siblings after the adoption. However, there is nothing in the order to ensure that. And we submit that if this court does not agree with us, that there should be something in your order that that imposes a legal obligation to do that. Because I think when family court decided this case, her decision is replete with indications that, you know, everybody's going to keep seeing each other. And I think that should be, that should be made a legal obligation.
Thank you.
Thank you.
Counselor?
Good morning.
Good
My
morning.
name is Erin Welch-Fair. I'm of counsel to the Onondaga County Attorney Robert A. Durr, and I am representing the respondent agency, the Onondaga County Department of Children and Family Services, on this matter.
Yeah, I'm showing my age when I call DSS.
That's okay.
Um,
So if I could just address Mr. Sarando's points, and I'll try to do it in order, but I might not. The first point being that there is no ongoing obligation by the department to continuously ask a relative for placement with the
Yeah,
child.
if I understand, let me help you along. Is that, if I understand the social services position is that there was no prejudice because whether there was strict compliance with 1017, at least there was some consideration. And they did seek out the aunt. Actually, that's what they wanted. And unfortunately, because she had two of the other siblings, it was too much for her to handle. That there's no continuing obligation for the department to seek her out through this process. And then ultimately, there came a time where there was a hearing on what was the best interest for this child, and the court made a reasoned decision based upon the evidence, and therefore, even if there was a violation, it really had no effect because there was no prejudice.
I believe that's true. I would note that the aunt did testify that she was approached by both the mother and the department at the time of the child's birth.
Yeah, I think that Mr. Sorrento, he acknowledges that.
What I believe was missing from Mr. Sarando's argument today was the fact that the Department of Children and Family Services did file a modification of placement petition based upon a further conversation that they had had with the aunt in approximately December of 2017 or January of 2018, seeking to modify placement of the child to placement with the aunt as a foster parent. And that the testimony from both the caseworker and from the aunt was that a conversation was held at that time in which the aunt indicated that she was in a position to care for the child, and the department then acted appropriately in filing the modification of placement petition. So that even though there is no statutory obligation for an ongoing duty to continuously ask relatives, that occurred in this case.
Yeah, and that was about a year or so after the initial.
Correct.
Okay, I think we understand.
And the aunt had significant involvement in the child's life and knew the ongoing issues that were facing the mother and the, I don't know if bleak is the right term, but the prognosis for the child to actually be returned to the mother's care by the winter of 2018 was pretty dire. The second portion pertains to the obligation of the department and of the court to find that the child's best interest is in the placement with the siblings. And the Department of Children and Family Services acknowledges that it's preferential for a child to be placed with siblings. And the statutes and the case law do make an obligation to reunify placement with the siblings. But that's a presumption and it's not irrebuttable. Furthermore, much of the case law revolves around the idea that it's a reunification of a family, whereas that's a different case where Jada had never resided with her siblings and had visitation and continues to enjoy visitation with her siblings.
What do you say to Mr. Sarando's last point about the order? We should modify the order to make it clear that there shall be regular and consistent visitation amongst the children.
I don't believe such a modification is necessary. There has been continued visitation between Jada and her siblings, and following the hearing and the disposition on the termination of parental rights petition, as well as the ruling on the custody for the aunt, the attorney for Jada at the trial level did file for sibling visitation, but withdrew that petition as it was unnecessary. And they've continued to enjoy visitation.
Okay, thank you.
Thank you. Anything further?
I don't think so. Does anybody have any other questions?
Thank you.
Good morning, Your Honors. I'm Lisa DePola Haber. I represent the foster parents on this appeal.
Good morning.
I will not repeat with what Ms. Fair argued. I am in agreement with what Ms. Fair argued. What I would like to emphasize is that at the time of the trial, the pre-adoptive foster parents had preference under statute because the child had been with them for much longer than a year. At this point in time, the child has been with the foster parents for 4 years, and it is the only home, and they are the only parents.
Yeah, I guess what Mr. Sarando's argument is, and I don't know how this all, from a practical perspective, where it lands, but I guess his point is if Department of Social Services didn't, and the court didn't fulfill their obligations under 1017, that the fact that the children were with the foster parents for 12 months or longer shouldn't somehow work against his client if he didn't, if 1017 was violated.
Well, respectfully, Your Honors, I would submit that 1017 has not been violated. There cannot be an indefinite obligation for the county to be reaching out to a relative, which would completely undermine the goal of permanency. Mr. Sarando, if I heard him correctly, said that the county failed because they had an obligation to go back to his client once the Jordans, the relatives from Texas, were no longer in the picture, when in fact that is exactly what they did. By the aunt's own testimony, she was aware before the county even came to her that the Jordans were no longer an option. When the counties did come to her in January of 2018.
It's not as though she was unaware of what was transpiring during that 14-month period, whatever it was, between the time they're placed with the child was placed with your clients and the time that the department commenced to proceed on behalf of the aunt, right?
Exactly, Justice Kern. And she still delayed in January of 2018 in taking any action. She did not file her own custody petition until 4 months later and did so only as a procedural mechanism, so she had the right to participate in the hearing. And she's caused prejudice by her own inaction on this appeal. It took her 14 months from the time that she filed her notice of appeal to perfect. She has, her own inaction has put her in the position that she is in today. To briefly address the issue of best interest, the sole factor that appellant relies on is the relationship between the siblings. There was very little testimony about that, and the so-called expert testimony was a general opinion based upon Dr. Brown's knowledge and so-called research, none of which was specifically on this topic. She admittedly was not able to testify about any of the particulars of this case and hadn't even met any of the children in this case. Even more, Dr. Brown testified about the trauma that Jada would suffer if she were removed from her current foster parents. There was no testimony saying that she would or could recover from that trauma. Finally, with respect to Mr. Sarando's point that something in the order should require continuing contact between the half-siblings and Jada, again, adoptive parents have repeatedly made clear and have continued to follow through on their commitment to do that. There was nothing pending before a family court that would have warranted that order. There could have been a motion on behalf of the half-siblings to require that type of relief. Nothing that was not made. For that reason, we respectfully submit there should be no modification of the lower court's decision.
Is that issue even before us on visitation?
I'm sorry, Your Honor.
Is that issue even before us on visitation?
It is not, Your Honor. It was not raised in the brief, and it hasn't been before this court. Respectfully, Your Honor, it doesn't take a psychologist to know the trauma that would be caused from removing this child from the only family that she's ever known. There's nothing in this record to say that it would be in her best interest to do this at this point in time, 4 years into her life. That for these reasons, we respectfully submit the decision should be affirmed in its entirety, and this child and these foster parents should finally have some finality and permanency. Thank you.
Thank you. Good morning.
Good morning, Courtney Raddick on behalf of Jada. May it please the court, I don't want to be redundant and hit on the same topics, but just with regard to the 1017 issue, it does appear that the appellant is asking the court to make new law or put a new obligation specifically on the agency, which I don't think is even preserved for the review by this court. It appears that it came up for the first time in appellant's brief, so I don't know if that's even ripe for review. Nevertheless, there's
In other
this.
words, the continuing obligation?
Right, the continuing obligation, yes.
we
And I do
understand.
think the department met that obligation, even if there is one, assuming arguendo. Secondly, we keep using this term, keeping siblings together. It's important to note in this particular case, and all cases are on their own facts, so it's hard to find a case that will meet everything on point, but these siblings never actually lived together. So I don't think the term keeping them together is particularly relevant here. Jada does have a relationship with Ruby in particular, but the other boy, he's so much older that they don't have the traditional relationship that Dr. Brown was trying to emphasize in her testimony. Also, we know that you could be living in the same household and not have a terribly close relationship with your siblings, or you could have better relationship with friends that are your neighbors. So I don't think that we should just solely focus on the issue of keeping siblings together. And I think that just by way of an update to the court, a Michael B. update, Jada's doing very well. She has turned 4. The parents are working from home. The foster parents are working from home right now, but Jada's been going to a daycare with the foster mother's mother. So she's still doing really well. And I don't believe she's seeing the aunt that much, but she has been seeing Ruby. And I think that it's time for her to have permanency after all these years. If the court has any other further questions.
Any questions? Okay, thank you. 1,000, matter of Jana R. Baychak? Yeah, we can't hear you. Your mic is probably off.
That better, Your Honor?
Yes, it is.
Okay, sorry about that.
No, no problem. Please proceed.
Okay. I think one of the glaring things in this case is Jeremiah was in psychiatric care. In fact, he was hospitalized for an extended period of time, followed by an extended period of mental health counseling, yet none of his records were submitted into evidence. Now, surely the child made some statements to one of the providers somewhere, but there is nothing really in the record tying in the mother's conduct to the child's misconduct. So that's one of the glaring things.
Counsel, doesn't the timing suggest that?
Well, they say he was, or the Miss Christiniak testified that he was discharged with a diagnosis of PTSD, but we don't have any professional diagnosis telling us what the cause of that was. If that was the only diagnosis, in fact, what was the cause of it? Certainly he was hospitalized, and certainly it must have been serious, but we don't know what it was. Was he also hallucinating? We don't know. None of that stuff came into the record.
But that wasn't the only thing that occurred. There was also his behavior at school during the fall of 2016.
Yes, but I would separate his conduct into two kind of categories. The first category are fantastic events that are not corroborated. And the second category are kind of more believable events, and that is the category of event that the family court focused on and made its findings. Let me just back up and explain what I mean. The child's, Jeremiah says, Mom beat my 4-year-old sister in the face. There was blood all over the place. Well, nobody saw any bruises on the 4-year-old. Nobody saw any blood. There was no corroboration of that. He says, I woke up in the middle of the night. Mom was choking me with a plastic bag. No corroboration of that. Mom hit me with a belt buckle to the point where I was bleeding. Well, there was a caseworker present during that visit. Caseworker didn't see anything. And then there's the hot sauce bottle incident. Jeremiah tells his teacher about he was hit by a hot sauce bottle in the face. He tells his grandmother in the presence of his younger sister he was hit with a hot sauce bottle in the face. Caseworker goes out to interview both Jeremiah and Janai, and they both deny that it ever happened. So the family court doesn't use those episodes, but I'm invoking the doctrine of in falsis uno. If somebody is testifying, or if somebody testifies to something that's patently incredible and unbelievable, you are entitled, if not obligated, to discount or disregard the rest of the testimony. So let's go through what the family court judge did find. Extended standing in a corner for an hour, 2 hours. Well, when you look at the actual testimony, the child, well, both children, if they're made to stand in the corner, they're provided with a beanbag chair to sit down on. According to the mother's testimony, Jeremiah was made to stand in the corner on one occasion while she prepared dinner. He came in, he had dinner, still wouldn't settle down. So she put him back in the corner, in his beanbag corner, while she did a load of laundry. I think she said it was a 15-minute drying cycle.
Counsel, didn't the court seem to focus more on those times when the mother didn't supervise the children, such as the Flatiron incident?
Right. And Mom admitted that she erred in leaving the cord dangling down. Does that mean Jeremiah is entitled to pull things down from the shelf or the chimney or whatever it is? No, she appropriately disciplined for him, but she also appropriately took responsibility for leaving that cord hanging there. She shouldn't have done that. Fortunately, the child wasn't seriously hurt. It was, a household incident, and nothing really seriously came of it. Did that warrant government intervention, that one incident? I kind of don't think so. Then there was the jumping off the roof of the playhouse. There was a caseworker sitting right there who did not intervene, did not take the child off the roof. There's no testimony as to how high this roof was. The mother was
By did not intervene, warning the mother that was dangerous, that's not intervening?
Well, yes, I would call that, yes, I would agree that is intervening. But I would think if the child were in serious danger, the caseworker would have leapt to her feet and taken the child off the playhouse. But in fact, the child didn't jump. The mom was teasing the child. She didn't jump off the playhouse and was in fact not hurt. So does that warrant government intervention? And finally, there were the supposed sexual images on the phone. There was a caseworker present during that visit as well. Where's the phone? What was on it? We don't know because the phone was never inspected. So aside from that, we have the in-camera interview, which for the reasons I stated in my briefs was improper. The children in this case are directly testifying against the mother. That shouldn't be held in chambers. The Court of Appeal says that testimony either has to be cross-examined or corroborated. Neither of that happened in this case. Are there any questions?
No.
Well, thank you, judges.
Thank you. Okay, Counselor.
All right, thank you. I believe I'm next.
Yes.
All right, so may it please the court, my name is Rebecca Hoffman, attorney for the Department of Social Services. DSS was not the petitioner in this case. This neglect was actually filed by the attorney for the child. And so I'll just make a few brief statements in response to Mr. Pajak's arguments, some of which were raised for the first time during oral argument. One, the government was already involved in this case. The children had been removed 2 years earlier due to a prior neglect petition. So this all happened in the context of a 2-year failure on the mother's part to have her children returned to her. With regard to the child's diagnosis of PTSD, that was uncontested at the trial, and the mother's failure to provide an alternate explanation for her child having PTSD is sufficient corroboration and leaves room for the court to draw the conclusion that her conduct is the result of that diagnosis and that the trauma came from her actions and actions regarding the children. Many of the statements that appellant says were fantastical on appeal were in fact admitted to by the mother, including the photos of her in a state of undress wearing a Santa hat. That was originally called fantastical. However, the mother confirmed that in her testimony. And with regard to the child's statement about the hot sauce bottle, we don't know that that didn't happen. The mother did admit that they'd had a fight that morning. So there's room for the court to draw that conclusion if they wanted to. However, the court wisely limited its decision to the statements that were admitted to by the mother. And the department has a very strong interest in maintaining the court's ability to determine what constitutes corroboration in an abuse or neglect matter. These are very private events that are happening in the home, and we need all the evidence that is available in order to make these determinations. And we would ask that the court now not narrow that discretion and allow family courts to continue to use any other evidence whatsoever to constitute corroboration of a child's statements.
Thank you.
Thank you.
May it please the court, Audrey Rose Herman, Children's Legal Center of Buffalo, attorney for the children. And I'll say first that I am only the appellate attorney for the children. I was not the trial attorney. Rebecca Talmud prosecuted this action on behalf of our clients. And I would say that it is definitely undisputed that there was harm, especially to the oldest of my 3 clients. He had a series of behavioral issues at school that eventually led to inpatient psychiatric treatment. That the harm existed, it was not contested, so there would be no need for records. And certainly the records could have been brought in by the appellant if she thought there was anything in there that maybe could have helped her case, and she didn't either. So I don't think that there should be any bias to either side that the records didn't come in. The harm was obvious. So
Let me ask you this about the instance, which I thought was bothersome, was the standing in the corner all night. That wasn't in relation to connected to the incident with the iron. It was connected, as I understood it, with the hot sauce incident. Am I correct on that?
I think the record is pretty unclear about how often the standing in the corner happened. I think there were 2 different times when it could have. I think Ms. Talmud tried to pin that down when questioning the mother, because the one time the mother had said There was discipline by excessive, by standing in the corner. She obviously didn't admit that it was excessive, but the standing in the corner, where then the next morning, Mr. Willie drove them to school on a Monday, and then she also said it in regards to the flat iron incident, and there was one about driving the kids to school.
Well, you
on
would
Tuesday.
agree that just the Flatiron incident isn't that substantial to make a finding of neglect. I mean, the mom was in the kitchen doing laundry and cooking dinner. This could happen to any parent.
Absolutely, I
You
agree.
know, it's
that-
not perfect parenting, but things happen when you have children, and it's not as if it's that outrageous.
Right, Your Honor. There are a couple of incidences in here that are brought up that I think standing alone probably wouldn't have been sufficient, and that Ms. Talmud wouldn't have brought an action based on just one of these incidents, for example. The flat iron incident could have been just a normal household action. However, there are a lot of different incidences. And then when you combine those with the complaints of the child, that the child was regularly dreading going to the visits. His teacher said on Fridays his behavior would get worse before the weekend visits with his mother. And on Mondays, he would come and complain about the visits to his counselor, say some of the things that happened. And a lot of those are corroborated. I think the big one is when I think the excessive standing probably happened, which was that Columbus Day weekend, which would have been the day that mom would have taken the kids to school on a Tuesday. The child showed up at school disheveled, wearing inappropriate clothes. He was very upset. He told both his counselor of what happened, which included the hot sauce bottle, included the excessive standing, included some fights with his mom in the morning. He told the same story to the custodian. His sister told the same story to the custodian, so that would corroborate it right there. But there's also the observations of the teachers and the counselors of his disheveled state, of him being upset. His actions and behaviors were very different. He was quoted as being very anxious and fidgeting and covering up. And just his affect was different, which could be corroboration too. I mean, the definition of what would corroborate a child's hearsay statement is very broad. And the case law, indicates that really anything, and it can be the record as a whole that can corroborate these statements. So in this case, there's a number of different incidences, including the fact that the mom does admit to using standing as a punishment. She's unclear as to when she used it and really kind of for how long. So I think that's
we see a lot of bad parenting in these Article 10 cases, and in the scheme of things, this seemed fairly mild. Not that it doesn't meet the threshold, but nothing. This seems like if this is the standard for the government to get involved in the families, then there's going to be quite busy, because there's a lot worse neglect going on than this out there.
I think what really brought this one, though, is the extreme harm that was happening to this particular child. And really, the oldest child is the one who suffered most of it.
Yeah, in other words, the effect on the child.
Yeah, I think it is.
Okay,
It is the
I
effect.
think we
These
understand.
are incidences that maybe wouldn't have that. I don't know if Your Honors would like me to address the in-camera issue. Certainly, there is case law that would say that if you're going to use the in-camera as your corroboration, then yes, appellant's, attorney, the respondent below's attorney probably should have been able to participate.
And
However,
there were questions, weren't there questions that were put in, or no?
I don't believe that there were questions put
Okay.
in. Yeah, that would be a type of participation that perhaps would have been
So there was
appropriate.
no
in this case.
participation?
As far as I know, there was no.
They offered the ability for questions.
Oh, okay. They weren't, the questions submitted weren't part of the record, so I don't know. There was just the offer.
Isn't the question here, though, whether or not this hearing should proceed under without counsel present in a neglect proceeding? Isn't that the issue here?
Right. And so I'd say first, the in-camera hearing was held sort of for two purposes. This whole hearing was held for two purposes, right? There was a 1062 motion pending for the return of the children to the parent that was held concurrent with the fact finding on this neglect. And so I would argue that, the in-camera really could have only been used for that. And certainly in the decision, the judge didn't rely on the in-camera as corroboration in any way. So I think that this is distinct from any case where the in-camera that, didn't have participation by the parent would have been improper. So I ask that this court affirm the decision below.
Thank you. 1001 Tartaglia versus Tartaglia. Looks like the appellant is submitted, but we have Mr. White, Ms. Mueller.
Good morning, Don White for the respondent, Father Chris Tartaglia. Briefly, I think the father's testimony established the requisite change of circumstances to justify looking into the modification of visitation by prohibiting contact by John Mike Prada with the children. The father testified that the mother had some sort of a relationship with Mr. Prada and that his children were frightened when they saw Mr. Prada's vehicle in their mother's driveway.
Counsel, there's one thing that kind of jumped off the page for me as I was reading this transcript. And it's on page 89, and the father said something to the effect that, gee, Mr. Prada is not allowed to see his own kids. Why should he see mine? Is that really kind of at the heart of this issue here?
Well, it is, and he did testify to that effect, and I submit that this case, because of that, is very similar to this court's decision in matter of Kramzak v. Salick, where essentially this court affirmed family court's order that prohibited contact with the father's girlfriend based in part on evidence that the girlfriend, just like Mr. Prada, had restricted visitation with her own daughter. And I think it's significant that by the mother not testifying, there's nothing in the record that establishes exactly what was her relationship with Mr. Prada. And referee Polito invited mom to that if it was a significant relationship and that she could come back and perhaps that would justify that at that point it would be in the best interest for the children to have some contact with him. But given, you know, the tenuous relationship apparently between mom and Mr. Prada, I think the court was justified in determining that there was really no benefit to the children to have any contact with Mr. Prada, and why create an unnecessary risk to their, you know, health and well-being.
Okay, thank you.
As far as the claims of bias, that's really unpreserved. He didn't make a motion. There was no motion to recuse. And in any event, I think it's without merit, and for some of the due process arguments, I'll defer to the attorney for the children.
Okay, thank you.
Elizabeth Moeller, I'm the attorney for the children in this matter. I would agree with the respondent's counsel that there was clearly evidence on this record that the children were afraid of this person and that there was no benefit to them being around him. And that this person coming into their life was a change from the prior order, justifying a new order, a new inspection of their interests. I have met with my clients since the appeal, and they continue to not be interested in seeing him. They say they suspect that their mother sees him, but they don't see him. And so this arrangement seems to be working out well. If there is some relationship, again, there was no relationship on the record. It's unclear if this is a significant other, boyfriend, who this person is to the mother. But if there is a relationship, she's able to conduct that relationship away from the children without there being any difficulty. And so I think it's clear that continues to be in the children's best interest for him not to be with them. And again, as to the due process issue, the mother had every opportunity to participate and chose not to, and that is clearly not any infringement on her right to due process. She could have participated, she could have testified, she could have significantly shed some light on what the real situation is here, but she chose not to, whether that was a trial strategy or what the purpose of that was. It was her decision. She had counsel throughout the proceedings, so there's no reason that she couldn't have participated if she chose to. And I would note that the cases I rely on in my brief seem to make it clear that despite the fact that she didn't testify, the family court was well within his rights to make observations of the mother while she was in the courtroom, and therefore he was well within his authority to make certain conclusions based on the mother's demeanor and during this proceeding.
Thank you.
Thank you.
Thank you. (10:03, 10:04), Reedman versus the Town Board of the Town of Mendon. Justice Lindley is recused. Okay, we're all set. Proceed, please.
May it please the court. I'm David Sealing. I'm appearing on behalf of Sheldon Boyce, the town attorney of the town of Mendon. The appellant is the town board of the town of Mendon. We seek reversal of 2 orders of the Monroe County Supreme Court issued in a combined Article 78 petition and complaint concerning a 2004 planned unit development district, often referred to as a PUD district, and a successor 2017 PUD project in the town of Mendon.
We know the facts and the record very well, so you can go right to the heart of your argument if you don't mind.
Yes. The town board is here because the court below erred in directing the town board to meet obligations it would have had under the paragraph of the code concerning a new submission project, while at the same time depriving the town board of its opportunity to have a legislative.
We really have to read that section, subsection G, correct?
Could you repeat that, Your Honor?
I'm sorry. We have to read that subsection of the town code. I think it's 217G, whatever it is. I know it's a G, right?
G is what the respondents advocated for in the process that they engaged in.
Don't we have to decide which party is reading it correctly?
That would dispose of this matter.
On that issue. So,
yes.
and we're to construe it against the town, correct? If there's any ambiguity?
I would imagine so, yes.
Okay.
The paragraph E is the paragraph of the code in which you would find the legislative determination. In this court's prior rulings on PUD districts, there are some elements of those zoning decisions which are legislative in nature, some which are administrative in nature. The legislative determination is captured by paragraph E, which below the town board of Mendon argued that paragraph E should apply. It had been well over a decade. It was a substantially different project. It was the town board hoped for, sought, and in a roundabout way achieved a right to have a legislative up or down vote on the project. We disagree that that right or that obligation and that duty under the town law was found in subparagraph G as the court below ordered it. Under the town code, under paragraph G, the town board never has the opportunity, much less the obligation, to review a sketch plan, which was what was submitted, that has been.
Well, shouldn't you be stopped from relying on that, given how the applicants were essentially directed to rely on subsection G?
I think it's arguable that the town acquiesced and subsection G should apply, but we would still argue that it should strictly apply as written. I would refer the court to a decision issued not 3 weeks ago here. I believe the decision was Churchill v. Hamburg, October 2 of 2020, where where the language of a town code's relevant provisions are clear, there's no need to interpret them. Under the.
And that gets
explicit-
back to my point that we really have to look at that section or those sections and determine whether or not we agree with you or the other side on that issue, correct?
That's correct.
What about with respect to the sewer agreement? Can you talk to me about that? Talk to us about that, please?
The sewer agreement, below it was decided on estoppel for the fact that because some members, and it's not clear which members of the town authority structure participated in negotiating terms for a modified agreement. The court below held that.
Have you found a case where a court has intervened in the legislative process and said, you must sign this contract?
To the contrary, Your Honor. There are
that would leave us with the 2006 agreement, correct?
Could you repeat that?
I'm sorry. It's tough with the mask on. And I appreciate you bearing with us. But if we agree with you on the 2018 sewer agreement, then we're left with the 2006 sewer agreement, correct?
Yeah, I think the same reasoning below that I think responded to the town's recognition that the contract was void and said that's a unilateral withdrawal. I think that same reasoning should apply and prevent the court from ordering a unilateral modification. It's a substantially different plan, and I think that we did provide some case law from this court. I can direct the court to it. It's in our brief.
That's right. We've read it.
Where, a project like this, which is substantially different, it really ought to be treated as a new submission. And frankly, whether or not the planning board in this matter ever approved the revised submissions, when you get into the minutes of that meeting and see how that August 13th letter was generated, it was always conditional on that sewer agreement. Without the sewer agreement, there is no planning board approval. Without planning board approval, even under the respondent's interpretation of subparagraph G, the town board had no obligation or opportunity.
But whether that sewer agreement is enforceable or not, and whether or not it meets out the criteria for a new application, that's apples and oranges, right?
I apologize again. You can't see it, but I
In
want
other words, whether the sewer agreement is back in place because it can't be terminated unilaterally, and whether it's enforced, and whether that old sewer agreement meets out the current project under a new and fresh application is a different issue.
Yes, Your Honor.
Okay.
And I don't think that, no one below argued that we should maintain that 2006 sewer agreement.
Okay, I think we understand.
Let's go to page 12 of your brief, Mr. Sealing. There is some reference to that the town, it's outside the record, but you put in your brief that there's been some more recent recodification of the town code in this pertaining to this application?
My understanding is that the recodification was infirm for lack of proper notice. That
I'm sorry,
recodification.
I didn't hear you. What was that?
The reasoning for striking down the recodification below, which was an entire recodification of the entire town code, was a result, it was based on lack of proper notice. The notice provided only said we're recodifying the entire town code.
Right,
It didn't
okay.
specify this will have a zoning impact. Based on the court's decision, my understanding is that the town has corrected that defect in notice and recodified the town code.
But that's not before us on this record.
No, Your Honor.
Okay.
And even the recodification discussed below was not applicable to pending applications. It was put into the ordinance that was struck down below.
Okay.
Would you say that if we, just for the sake of argument, if we agreed with the lower court with respect to invalidating the code, the local law 2018-3, whatever it was, if we agreed with that, do we have to reach the special facts issue in your view?
In our view, special facts, the court's finding below that the recodification was insidious, when you read the decision, is supportive of the special facts, but it's not the end of the inquiry. Special facts is also premised on a vested right, which the court below did not support its finding.
And I'm sorry to interrupt you again, but it's not really on my question. My question is, in the event, assuming arguendo, that this court agrees with the lower court that the voiding of the 2018-3 local law, changing the code, if we agree with the town, the lower court that that was properly done, do we have to reach the special facts issue as far as you're concerned?
I would think it stands as some evidence to be weighed in a special facts determination.
So we should still reach it in your view?
I think it's an issue that's been raised. It was properly addressed below. We just disagree with the outcome. I wouldn't say that it's outside, that it's an issue that can't be reached.
Right. And I don't mean to
especially
rush-
if you concur with the court below that recodification was improper.
And I don't mean to rush your argument, but I want to make sure you touch on the attorney's fees issue at some point.
Yeah, and please be careful of your time.
Thank you. In our brief, I discuss a federal case which largely discussed all of the cases relied on below, because there's not too many when it comes to the sewer agreement and these PUD cases. This court's holding in Cerberus supported the whole finding below. And Justice, now Supreme Court Justice Sotomayor's club-side decision sets a requisite for the award of attorney's fees as a guaranteed federal right.
They have to have basically a vested property right, which you would say they do not have, correct?
Which is similar to the analysis of special facts. I wish I had the correct citation right in front of me. Your Honor, I am comfortable with the way that's addressed in our brief, but my understanding is that under the federal jurisprudence on this issue, you are required to have an interest that is so certain. Now, even the finding below saying that the court couldn't order the town board to approve the project, I think that per se shows that the outcome is not certain. And that is our position.
Okay, thank you.
Good morning. May it please the court, my name is Robert Cagle. I represent the respondents, the developers in this case, Reedman and Ryan. I'll get right to the questions you were asking of the town board. The first thing you asked about is what is the process we are to apply for this modification? What part of the town code? 217G, F, or J has been raised on appeal for the first time. In an effort to get that clarity, because statutes are not always clear, but in facts change things a lot. In May of 2017, I wrote both the town attorney by email and the planning board attorney to clarify the process that we would follow. The planning board attorney.
So if I understand it correctly, you would say that first of all, G fits, right?
Yes.
And if it doesn't, they're stopped.
Yes.
Got it.
And if so, I guess you understand that point, and I made it the timing involved with it. There was no objection to this procedure until the litigation. That's 2 years later. And this idea of J, subsection J, on this appeal more than 3 years later. So that's that one. Sewer agreement. We have a 2006 effective sewer agreement. And we intend, and we've asked again for this court to confirm, as the court below did, that that agreement is in effect, that the attempt to annul something, an agreement that the parties agreed expressly could not be unilaterally changed, puts that agreement.
And in fact, you argued in your brief, didn't you, that if for some reason we set aside the decision to invalidate to validate the 2018 sewer agreement, that your fallback was at a minimum, the 2016 is valid and was improperly set aside unilaterally by the town. That's your point.
Yes, it is, Your Honor, and as you understand, because that gives us the power for a 54 lot subdivision as opposed to a 95, and that's important. So I think that this court understands the notion of the sewer agreement and the points that were made on the brief there. You asked about recodification, and it was said that here that the court below annulled the attempt of the town board to recodify its whole code only because of notice. You recall that hidden in that recodification with no express mentioning whatsoever was the elimination of the PUD provisions.
And if we, assuming arguendo, that we agree that the court got that right about invalidating the recodification, do we need to reach the special facts issue in your view?
Well, it's a good question, and I'm thinking about it, and I suppose the answer is no, if you do. Let me just add one small thing, that the court, when it did it not just on notice, but it also annulled the recodification on the failure to follow the comprehensive plan. And this notion that they are doing it now is nonsensical because they have not revised their comprehensive plan. And it's what they're doing now is outside the appeal anyhow. And I note that they didn't even.
Right, and that's why we wouldn't get to special facts at this point. Is that right? We don't know what the future holds.
That's right, Your Honor. So that's the special facts. Now, attorney's fees.
You don't really meet the vested right analysis for attorney's fees.
I don't think so, Your Honor. I'm reading the cerebus, I'm not sure if the right pronunciation case.
We're not going to know any better, so keep going.
Thank you. And I find that there are two things, that the federal claims, which are clearly stated in the sixth cause of action in the petition complaint, that those federal claims arise out of the same nucleus of facts as the state claims, the Article 78.
That's a little different, though. When you're talking about property rights, doesn't the club side, or whatever that case is by now Justice Sotomayor, and the other cases that it cites to, when it comes down to real property like you have here, don't you have to show a vested right to the extent that it's a near certainty, and there's no discretion to deny it? I thought that's what the cases say. And do you have that here? And I realize special facts analysis, if we were to get there, would be slightly different. But just tell me about this vested property right that you supposedly have.
Yeah.
How close are you to getting it done?
Well, I think we had a vested right in a zoning, in the process of zoning, so that you cannot take away a person's zoning classification by fiat, by town.
But at best, you have an if come. Would you agree?
Pardon me?
At best, you have an if come, so to speak.
Well, we had it. We had a vested right in a particular zoning classification, which we went out and got by court order. And for that to go away, I'm not saying, of course, that they can't rezone properly, but they didn't. Their first attempt was to simply say it reverts. You know, the statute says that it reverts. They just did it by attorney point of view. And the court found that that was not right. And I find that to be an assault on the basic rights of.
You would say you have a vested right in the process.
Yes, I do.
And we have to look at whether or not that's enough, or whether we have to see a vested right in the property that's protected by the 14th Amendment.
Yeah, I think you need to look at those, yes. And I would say, I did read Cerebus to say, that as long as the federal claims were not wholly insubstantial, now maybe that's the way I read it, wholly insubstantial, then attorney's fees are in order. And that's what I was relying on.
Okay, thank you.
Thank you very much, Your Honor.
(10:05, 10:06), Dennis versus Mark Cerrone, Inc. Good morning.
Good morning, Your Honors. Sean Cooney on behalf of the appellant, Joseph Dennis.
Mr. Cooney, if I understand your point correctly, among others, words matter. That is, when the court grants a directed verdict, it's finding there's insufficient evidence as opposed to deciding on a verdict where there's weight evidence. And since the court said there was insufficient evidence, you would say, if I understood your brief correctly, that that's contrary to our previous decision that said there's a and the previous concession that there's a question of fact.
That's correct, Your Honor.
And you're asking us to send it back for a new trial.
That's correct, Your Honor.
Yeah, I don't think there's any question. I don't even understand. Unless there was less proof that came in at trial than what was presented with the previous motion for summary judgment and the appeal, we were clear. Or I should say they were clear that they acknowledged or conceded that there was a question of fact with respect to whether Mark Cerrone Inc. Had the requisite authority and control to supervise the work. And to Justice Curran's point, the court, under this procedural context and the facts, it just didn't, it was outside their ability to do, or authority to do that.
That's correct, Your Honors.
You first.
Let me ask you this now. Where's this 200 claim? What's your position with the 200 or negligence claim?
The 200 claim stems from the simple facts surrounding the unsafe condition.
Okay, so there was below and above, you're not arguing it's a means and manner case. You're arguing it's a dangerous condition case.
That's correct, Your Honor.
Okay.
It's a hazardous opening.
And is it your understanding, is your position that the law in that area, if we were to couch it in that term, your position is that the court was in error also because they directed verdict on that?
Correct, Your Honor.
Okay, and so you still would have the burden you'd have with, or the obligation to prove the issue about the requisite authority for all three claims, 240, 241, and 200.
Correct, Your Honor.
Okay, and then once that takes place, is it your understanding that the other hurdle would be whether or not this dangerous condition was, so to speak, produced by the work, or whether it was just an ordinary dangerous condition premise case? You understand my point?
You mean specifically related to the 200 cause of action, Your Honor?
That's right.
I think related to the negligence cause of action, no. Related to 200 in order to be covered, I think that is accurate. This is an ongoing construction site, though.
Yeah, I guess.
Maybe I'm not understanding the question.
No, you're understanding, because you cited to the second of Judge Dillon's cases, right, in your brief?
Correct, Your Honor.
Okay, so you subscribe to this Silka's case that you understand?
Correct, Your Honor.
Okay, and so you're suggesting that you would have to prove control with 200, but not with negligence?
I would say that the duty of the defendant is to act reasonable under the circumstances, which would include elements of proof regarding their control over this hazardous opening.
Okay.
Right. What if we, and I agree with, on the 240 sub 1 and the 241 sub 6, our decision in the prior appeal, right or wrong, would seem to control, unless, as Justice Carney said, the evidence was different at trial, which it doesn't seem. It looks like you had more evidence of authority and control at trial than you did on the summary judgment. But on the 200 and the common law negligence, isn't it possible in theory that we could affirm on the ground that it's a means and manner case, not property defect case, and that there was no MCI did not supervise or control the plaintiff? That would be a valid theory to affirm the dismissal of those two causes of action while keeping in the other two.
I don't disagree with that articulation of the law by either of your honors. I would say that under these facts, what is a little bit different is that the characterization of a means and methods versus MCI's control over the actual hazard overlap factually. And what I would say, the factual evidence of MCI's 200 responsibility include they were the company that purchased the very material used to create the opening, the very material used to cover the opening. MCI's representative testified he observed that prior to the fall, that he understood how to cover it. He knew where to get the material to cover it. In fact, he arranged for that material to be delivered.
But, you know, their argument on the other side is that the hole was intentionally cut as part of the job, and that to put the framing up, they couldn't cover it. They had to remove the cover. But let me ask you this procedurally. If this were a jury trial, or in this non-jury trial that we have, is that an issue that needs to be resolved, whether it's a property defect case under 200 or a means and method case. Is that an issue that we need a verdict on?
As opposed to a directed verdict.
Yes.
Yes.
Verdict at trial, that the court has to make a determination, okay, this is, I'm finding it's means and method, or I'm finding it's proper because there's two separate standards that apply, and then say whether plaintiff met their burden of proof.
Correct.
Which, supervision and control and so forth. So you're saying in that it should go back, the court needs to make that determination. You want it to be a property defect case. It's easier for you to prove, I think.
I think there's no doubt that as a hazardous condition or a property defect, that type of 200 liability is a lower burden for the plaintiff to demonstrate
Right.
control. I do think here, given the facts that I just referenced about the control over the very device to provide the cover, that even if it were a means and methods purely, the defendant's representative who controls the very means and methods that would be used to cover the hole and was aware of it, I have met that burden. And I think importantly that 200 was in this case when we were before your honors in 2018.
Yeah, but it didn't make its way to the memo, did it?
It did not.
To our decision,
But the cause of action was preserved. In response to my papers today, the defendant doesn't really address the 200 argument, which is probably why your honors are focused on that. It's not.
Mr. Cooney, I'm sorry don't lose your train of thought, but I'm having kind of a brain freeze, forgive me. But under 200 and or negligence, can the contractor as opposed to the owner be held liable?
Yes.
Under negligence?
Under negligence, yes.
Go ahead.
I think any citizen, any company, any person has a duty to act reasonable under all the circumstances.
yeah, so in other words, like with the difference between, in my understanding, and I'm going to ask you if this is your understanding of the law, there is a distinction between 200 and negligence, because even if you don't control the work site, and you could still be held liable under negligence and not 200 if you created the condition.
Yes,
You have
Your Honor.
case law that suggests that?
Yes, Your Honor. I think
Okay.
if a covered work under Labor Law 200, a company would be responsible for creating a hazardous condition in
Right.
addition to that.
And
in
then
addition to
there's the
negligence.
distinction, and I don't know if I made myself clear. The way I read the second department cases is that first you decide whether it's a means and manner or a dangerous condition, a premise type case. But within the dangerous condition on the premises, it still could be, there's still another distinction. And the distinction being that was the condition created as an integral part of the work, so to speak, versus whether it's just a regular dangerous condition premise case.
Something that should be remedied, yes.
Because
And I
in
would
that
say,
the second department case, what they found was that it was not a means and manner. And then when they went to the premise case, it was a painter. They said, hey, that was done. And this tool that they left out turned it into a pure premise case.
outside of the ambit of Labor Law 200.
May have been different if that was left out as part of their tools when they were actually performing the paint.
I understand you. I think this case squarely is within 200, given its context of being in the construction context, and most importantly, because of MCI's control over the actual device itself.
Okay, and you may have answered this question for Justice Lindley already, but in other words, if we agree with you on the issue that the court jumped the gun, so to speak, with the directed verdict, and we were just to send it back down on the requisite authority issue and keep in all three claims, you folks will work it out. Otherwise, we don't need to direct anything else. The record, it is what it is.
I would say that the other aspects of my case were not opposed in the record.
Mm-hmm.
And there's no basis to retry the issue of the underlying failure to provide the proper protection.
So we would send it back to the judge that heard this and based upon the prior proof, he would be required to just give a decision on the facts.
I think given the legal determination that was made, I don't know that the presiding judge could make a factual determination after having interpreted and weighed the evidence under this legal evaluation that's inconsistent with this court's prior ruling.
So
In other words, you
asking?
want a new judge?
I think I would need a new trial.
Then you, okay.
Right, you can't get a new judge to render a verdict on the case that he or she didn't hear. In other words, you don't want us to just send it back to the court, because this is a little unusual, which is confounding to me, is that the proof was closed. It was a directed verdict, but the defendant offered evidence and the defendant rested.
Correct.
No earthly reason why the judge couldn't just render the verdict. And his decision on the directed verdict reads like a verdict. I'm not sure what the thought process was there. But he issued a directed verdict. We said issues of fact on authority for the 240 sub 1, 241 sub 6. So you say at least that much has got to go back, but you don't want us to send it to that judge to tell us the verdict. You say you want a new trial.
Yes,
entirely.
Yes, Your Honor. I don't know how a judge could hear the evidence, could reconsider the evidence if they've evaluated it once under the wrong legal framework that's inconsistent with this court.
Right, you don't want the same judge because you know you would lose on that with that judge.
I would never say I know what will happen, Your Honor, but I do think the case law supports a new trial, not a remand for reconsideration of the evidence.
No, sir, it wouldn't be a remand. Wouldn't the court have to make, as required by the CPLR, findings of fact and conclusions of law? We don't have that. So if you were to send it back, you'd have to make his findings and make a final determination looking through the proper lens, not the directed vertical lens. Why can't that happen?
I think the court has, the case law supports a retrial. I think that's the language in the decisions for after a directed verdict is granted improperly. I did not see examples of remand, or maybe remand is not the proper word, Your Honor, excuse me, but where it is sent back to the same judge.
Those are jury trials, aren't they?
I'm sorry, Your Honor?
Those are jury trials, aren't they?
They are, and there are
Because
some.
that's the difference. I mean, usually with the jury trials, at least what I would do is, I'd let the jury do what they had to do, and then I'd rule on these other type motions in case the appellate division reverses me. They can reinstate what the jury did. But the cases you're talking about, a jury case, this is a non-jury case.
It is, Your Honor.
We can send it back to the judge, but I think we understand.
The answer, I think, is it's important to say that I could not find authority which specifies the proper way to deal with this type of situation, a directed verdict in a bench trial where there are other findings of fact that were not reached as a result of that.
Because it rarely, if ever, happens.
Precisely. And I think the case law that I did find from the Court of Claims and some others, I think there was one case in the brief. It did just simply said new trial.
Yeah, okay. Thank you.
Thank you, Your Honors.
Counselor?
May it please the court. The fact of the matter is that only plaintiff's employer, Shaliga Builders, had the requisite authority to control or supervise the framing work that plaintiff and his co-workers were performing at the time. Mark Cerrone is a general site and utilities contractor.
I know, but now you're getting into the facts here. The issue here is did the court, you made a motion for a directed verdict.
Yes.
When we sent it back down, this court said there were questions of fact based upon your concession. And so if we were to say, hey, we've looked at the record and tried to, apply the right standard, make findings of fact and conclusions of law, it's impossible. We just can't do that. We've already determined there's a question of fact. You made the motion for directed verdict. You should have let the court make a decision on it. We were perfectly clear with the prior decision.
Well, the court was the trier of fact. I think there's a difference between the jury trial and the bench trial in this case, because the court, as the trier of fact, heard plaintiff's case and concluded that plaintiff had failed to meet his prima facie burden. We offered no evidence on our case.
Okay, so let's hold that thought right there.
Sure.
So now what we did, and we did it, we had to march through the motion for summary judgment and march through the proof at trial and see if there was anything different. In other words, was there less proof offered by the plaintiff at trial than was offered in the motion for summary judgment? And to Justice Lindley's point, there was actually more proof offered, additional proof. So, that's really the issue. is what do we do with it now? Send it back down for the judge to render a decision using the right standard? Or does plaintiff get a new trial with a new judge and a do-over?
I don't necessarily agree that there was more proof in plaintiff's favor once it went down to trial.
Was there less proof? Was there any less proof? Anything that was in summary judgment that was relevant that plaintiff neglected to put in at trial?
Well, I think, for instance, the testimony of William Johnston. At the summary judgment, obviously, you're getting deposition testimony. Now, for some of these witnesses, Vincent Cerrone, the co-workers of plaintiff's employer did not testify at an examination before trial, but you had these people testify at trial. And I think the evidence was much stronger at trial than it was.
Right, but then you're talking about preponderance of the evidence and burden of proof and whether they prove the case. We're talking about legally sufficient evidence. And you had acknowledged previously, and we agreed with you, that there was an issue of fact as to whether MCI had the requisite authority to control and supervise the work site. So, and if that evidence was admitted by plaintiff at trial, how do we get around that and say, even though there's issues of fact from that same evidence, the defendant's nevertheless, MCI is nevertheless entitled to a directive verdict? How logically can we do that?
Well, Justice Bonello found that there was not one instance where Mark Cerrone directed or controlled the work that was being done on the site.
Right, well, that's contrary. That's contrary to your concession, because you said on summary judgment on the same proof there are issues of fact.
Right, and the issues of fact were resolved at trial.
Yeah, it does. I mean, to be honest with you, I know I'm giving you a hard time here, but it does. When you read the decision, it almost reads like he's making determinations. It's, not ruling on a directed verdict, but leading up to almost like the findings of fact and conclusions of law. But then he takes a turn towards what was pending before him, and that's the motion for the directed verdict. So if we were to disagree with you, counselor, and say, no, the judge used the wrong standard, what would you say we should do? If your choices were send it back down to the judge that heard it, and he would have to do findings of fact and conclusions of law, or send it to give a do-over and a new trial?
Obviously, as an advocate, I'm going to say that the former. Send it back down to Justice Bonello. We brief it if we have to. He makes a finding of fact, and that would be it. He did a Walls analysis on the agency issue, and in his decision, and concluded that agency had not been proven. And without agency or authority, is there any rational basis for the trial court to find in favor of plaintiff? And I submit that there wasn't.
And that would include the 200 claim that we were. Okay. Is there anything else, counselor?
No, Your Honors, unless you have further questions.
Okay. Thank you.
Thank you.
Thank you, Your Honors.
1007, State of New York versus Joseph R. Okay, Ms. Friedman.
Good afternoon, Your Honors. Catherine Friedman, representing Appellate Joseph R. in this appeal. Your Honors, I would like to start with my due process argument and actually address some of the points raised by the Attorney General in his brief. First, I think that contrary to the Attorney General's position, the issue of due process is adequately preserved by Joseph's motion that he submitted in August of 2016. Secondly, with regard to the time period at issue, I pointed to Mental Hygiene Law 1007A as the basis for the clock starting with regard to the speedy trial provision. And under that provision, it says very clearly that the court shall conduct a jury trial within 60 days. That being said, I know that the Attorney General has argued a lot in a lot of different cases that that 60-day time period is a goal that agencies should meet, and it's not mandatory. I respectfully submit, Your Honors, even if that is the case, if you look at the New York State Court of Appeals decision in matter of Benjamin L., that was a case that dealt with juvenile delinquents, but in that particular case, there was no statutory time period set forth in the Family Court Act. Notwithstanding that situation, the Court of Appeals found that in certain circumstances, an unreasonable delay can result in a due process violation.
Don't we have to look at the reasons for the delay, like your client went through a few lawyers and so forth?
So, Your Honors, I do think that that is part of this broader test that was set out in matter of key theft. And I think that's one of the prongs, certainly, that needs to be taken into consideration. What I am urging this court to do, and I had a similar case last term, is for the state of New York to adopt this balancing test in the context of these mental hygiene proceedings, just as speedy trial tests were, adopted in criminal cases and juvenile delinquency cases.
But even in criminal cases with speedy trial, if the delay is caused by the client, then it's not included in the timing. Didn't he make here a number of motions in addition to having the issues with the attorneys?
He did, Your Honor, but again, that's one factor under People v. Taranovich. There's People v. Taranovich also set forth a balancing of various factors. And I believe it was the First Department in matter of Keith F. Actually set forth a balancing test for mental hygiene cases. And so
that's the very same case where it said that the deadline's not strictly construed, isn't it?
So if indeed that's the case, Your Honor, I think then you can look at Benjamin L. and look at what the Court of Appeals did in that case where there were no timeframes, but they found that a 13-month delay in the context of that case was unreasonable. I would suggest, Your Honors, let's just for the sake of argument, say that the time period started clicking, the probable cause hearing was in June of 2013.
Yeah, they don't start proceeding to 2017.
That's correct, Your Honor. It's 4 years. It's 4 years.
Justice Joseph and I were on that prior case that you recently argued, a very similar.
Yes, very similar, Your Honor.
I have a question on a related issue, but I'll see if the panel has any more questions on this particular issue.
I just want to make sure I understand what you're asking us for. You want us to remit it and then have a hearing like we do for 3030 cases for criminal, and each time period, the court would have to determine whether it was chargeable to the state or chargeable to the respondent? Is that what you're saying we should do? Even though the statute doesn't require that, like CPL 3030, you want us to order that type of procedure in every case where it's more than 60 days?
I would ask this court in this particular case to set forth the balancing test of Keith F. as the standard, remit it back, and go through the criteria, the length of the delay, the reasons for the delay, which all of Your Honors have brought up. defendant's responsibility to assert the right in prejudice.
All right, counsel, what ultimate remedy are you seeking then? Let's assume that the court finds there to be excessive and unexcused delay. What are you looking for?
Yeah, so that's a great question, Your Honor. I mean, I recognize that in these types of cases, even though advocating for release is a little problematic, and I have thought about that question, and I don't have a clear-cut answer for you.
Right, because I don't think I was thinking that myself, but there are annual reviews, right? Your client is entitled to a review again.
Yes.
I mean, so if we were to say this hearing was untimely, okay, well, let's just make the next one timely. It's been over a year. I mean, why wouldn't he? It sounds like he's not entitled to outright release on a violation of this. So his remedy is a timely hearing, which he gets anyways. He gets a new hearing anyways.
I would suggest that, well, that he, in fact, be guaranteed a timely hearing.
Okay. The question I have is the contention about the court permitting him to proceed pro se, and that there's no right to do that, or no, under Article 10, doesn't permit self-representation.
Yes.
So are you, in addition to that, arguing, you're just saying, hey, you just can't go pro se, and that's the end of the inquiry? Or is there some argument there, because I'm trying to follow your point in your brief. Are you arguing, but if you can go pro se, that the criminal is there some standard then? Is that your argument? And the criminal standard is not the right standard?
I think, Your Honors, that this court is in a position to make clear whether or not people people under mental hygiene law have a right to proceed pro se or not, whether you adopt the criminal standard or some sort of civil standard. I mean, I have to tell you, these mental hygiene cases, as I'm sure you're well aware, are very confusing in terms of it seems as if courts take some things from the criminal context.
Right, we understand
some things from civil context.
Let me ask you this. When you say the standard, you're talking about the standard for what the court has to do relative to the inquiry?
Yes.
Is that what we're talking about?
Yes.
In other words, are you asking us if we come down and say, yes, you can proceed pro se in this proceeding, is your next argument that then we have to lay out a standard for when you can, and in other words, as to the proper inquiry to make sure that the individual knows what they're doing?
I do, Your Honor, and I think that having that proper inquiry, the criminal context gives great guidance with regard to what that proper inquiry looks like, and I think that if
is your argument that it would be a greater standard?
Not necessarily, Your Honor.
How about a lesser?
Not necessarily, Your Honor. I think that the criminal standard, is certainly adequate in these cases.
Right.
And
Wouldn't you agree that if the criminal standard were applied here, the court's inquiry was more than sufficient? The court inquired as to his educational level and his experience, and he seemed to acquit himself fairly well. He was asking for 5 hearings. If this were a criminal case, we wouldn't reverse on the court's improper inquiry.
Yeah, I would just, Your Honor, point to, it was just very confusing. I understand that the court did go through his education, trying to make sure that he fully understood what he was doing. If he held any jobs in the past, et cetera, but it was very confusing because the court used language like a clear and convincing evidence standard. And so I think it conflated. I just think it conflated issues.
One thing is clear is that if the court said, no, you can't go pro se, you'd be arguing right now that was error.
Yes.
Ms. Friedman, would it be appropriate in your view for us to look to cases on this issue as to what needs to be done when a respondent here or somebody in your client's position asks to be relieved of counsel and go pro se? Would it be appropriate for us to analogize to the standard used when waiving a right to a jury trial? And we have the case of Daniel J. that was decided within the last year that has that standard. It's based on a case out of the second department, 2015, Ted B. And it's knowing involuntary, and it uses a due process analysis. Would you say that would suffice?
Well, Your Honors, I'm not wholly familiar with that case, so I really would not be comfortable commenting.
Okay, let me just read you the language. That the waiver of the right to a jury trial must be in accordance with due process. There must be an on-the-record colloquy in order to ensure that the respondent understands the nature of the right and that the respondent's decision is knowing and voluntary after having had sufficient opportunity to consult with counsel. Would that be a sufficient standard to apply to this case?
That seems sufficient, Your Honor.
Okay, thank you.
Okay. And if there are no other questions, I mean, I suppose, Your Honors, I would, just like to reiterate the arguments raised in my brief with regard to the mental abnormality test and refer Your Honors to the case matter of Michael M. with regard to the argument that I raised concerning appellant's confinement. You have my other arguments. If you have any questions on those, I'm happy to ask them, or answer them.
Okay. Any questions from the panel members? Okay, I think we have it. Thank you.
Thank you.
Good afternoon.
Good afternoon, Your Honor. Frank Brady on behalf of the respondent. This court need not wrestle with the due process issue because it's simply not preserved. The motion that the respondent made was a motion to be released under the mental hygiene law. He wanted to move to petition to get out of confinement, and the court denied the motion, explaining to him that he wasn't at that stage of the proceeding yet. At no point did the respondent say that his due process rights was violated, his right to a speedy trial was being violated. And you know that there's a lack of preservation because respondent is asking this court in the first instance to make findings of fact that would normally be made by a lower court about time, who's chargeable for what periods of time. So the court need not address it. It wasn't raised below. And frankly, there's really no basis for it in the with respect to the statute, of course, because the statute says that all the time periods are just goals to be met. I'd also note that at no time did respondent declare he was ready for trial. He was ready. And a lot of the delay is attributable to respondent who they want this case. He moved for 2 change of venues. The case went through 2 change of venues. He had 2 attorneys that were relieved for him. And he also asked the court to appoint an independent expert to examine him. He admitted that he actually delayed seeing the independent expert because the respondent wanted to examine some of the paperwork before that took place. The expert that he asked for, that report wasn't even finished until 7 weeks before the trial commenced. So the court need not wrestle with this question because it's not preserved and there's no record for it to review in this sense. And in any event, the record doesn't support the idea that the state was responsible for any delay. In fact, twice in the record, the state announced that it was ready for trial, and that was never contested and that was never taken up by a respondent. As far as
let me ask you this though. We've seen these delays in a lot of cases, and they're well over the 60-day period that we're talking about. And sometimes there are reasons for it, but The delay seems excessive in many cases. What remedy? What should we be doing for these people when they're subjected to delays that are prolonged and sometimes perhaps unjustified?
Well,
What relief should they be accorded?
Maybe if they actually made a motion, to, for example, they could bring a writ of mandamus if they have a clear legal right to move forward and the court's not complying with that. 60 days, the idea they're going to have a trial 60 days after a probable cause hearing is when you consider the kind of evidence that the lawyers have to examine and the complicated nature of some of these cases and then the need to reach out to experts, that's not going to be met in most cases by either side. I mean, like, for example, in this case, respondent asked for an expert to be appointed. In this case, it was unusual, I think, because it was originated in Ulster County, then it went to Staten Island, and the respondent was in Manhattan Psychiatric Center for the time. And then his attorney there, the second time, an attorney asked to be relieved. That attorney said that the respondent wanted him to pursue strategies that he couldn't pursue in good faith. So then it got transferred up to Oneida County. So right there's a lot of delay. That's like a 2 or 3 year delay that was kind of once it got to Oneida County, it moved fairly quickly. And both attorneys on both sides, he had a third attorney at this point from MHLS, and both attorneys on both sides moved to expedite the matter, except of course, at that point, when he got to Oneida County, the respondent asked for that other expert, other independent expert. And that, like I said, that report wasn't ready until 7 weeks before the trial began. And there was a lot of motion practice, in between that. So it's an unusual delay. I don't know that there's a clear answer that I have for Your Honor. A writ of mandamus comes to mind if they could show that somehow the court or the state was dragging its feet. But a lot of times these delays are sought by the respondent.
But I mean,
and the record doesn't reflect that.
This is a civil proceeding, but there are liberty interests involved here.
I agree, Your Honor. I agree. But again, here there was no claim that there was any due process violation because of the delay. I suppose in any particular case, someone could make that, and the court would have to make that argument, and the court would have to wrestle with that. But such an argument implies the jurisdiction of the court losing jurisdiction, and I'm not sure that the mental hygiene law was meant to accommodate that kind of argument.
Do you wish to rest on your brief for the remaining points?
I did want to say that as to like what would be a good test with respect to proceeding pro se, there's a good discussion in Raoul L. Out of the second department. That's at 120-83rd 52, and they apply the criminal standard, which is obviously a heightened standard.
Mr. Brady, before you get to that point, along those same lines, would you say you argue in your brief that the CPLR applies, right?
The CPLR applies to being able to proceed pro se. Yes.
Right. And on that issue, would you say it would be enough when somebody in the petitioner's position stands up and says, Your Honor, I want to represent myself? Is the court then allowed to say, as long as there's no 1201 concerns under the CPLR, can the court simply say, granted, without doing anything further?
No. The court, I think, would have to conduct a searching inquiry, as it did here. This inquiry here on this record was very thorough.
Why would you have to do an inquiry if it's a straight up civil case and you don't have to do it in a civil case?
Because, well, I confess I'm not as familiar with the standards on the non-criminal, non-MHLL civil side. If a party wants to represent themselves,
But I think since we're talking about the mental hygiene law and this
Counsel, let
type
me
of,
interrupt you. Is it because there's a liberty interest here that the searching inquiry is the more appropriate standard?
yes. Yes. And that's why if in Raoul, they refer to, they analogize it to a criminal proceeding where there's this important liberty interest at stake. So the court wants to ensure that it's the pro se person can represent themselves adequately.
Okay, thank you.
If there's no more questions, I'll rest on my brief.
Okay, thank you.
Thank you.
Okay, 10:08, Barsky versus the town of Aurelius. Good afternoon.
Good afternoon.
Okay, you can proceed.
May it please the court. My clients, Aaron and David Barsky, and Barsky's Extreme Laser Tag LLC. We are seeking a decision overturning the granting of a summary judgment decision, dismissing the complaint against the town of Aurelius.
Counsel, can I think I got a roadmap here that maybe we can follow this. I think we can all agree that we're starting with the prong that this is issuing a permit is a governmental function. No one disagrees with that.
Correct.
And for the town to be liable, there must be a special relationship. No one disagrees with that.
Well, that's where, I think that's where.
Well, there has to be a special relationship. Whether or not one was established is factual here.
Right, that's where this.
Or in play.
Matter turns, yes.
Okay. Now, as I understand your brief, you contend that a special relationship was formed because the town voluntarily assumed a duty and you justifiably relied on that. Is that your theory of a special relationship?
In large part, yes, Judge.
Okay. Now, when you pursued under that voluntary assumption theory, there are 4 prongs to that.
Correct.
And on a summary judgment motion, if the defendant can eliminate one of those prongs, he prevails. Because you got to prove all 4. If he can eliminate one, you can't prove all 4.
Correct, that we need to establish an issue of material.
The prong that I wanted to focus on was, I think it's the second prong, knowledge that an action would lead to harm. You want to talk to me a little bit about that?
Well,
you agree that's one of the 4 prongs?
Yes, Judge. I don't think the lower court actually even got to that prong. I think the lower court had dismissed it on the first, I should say, granted summary judgment regarding the first prong. That being said, we believe that did happen here because where the town would know that, I should point out that it was the town's code enforcement officer and fire chief who were the 2 representatives of the town who were in communication with my clients. And when
What was the inaction? Why don't you get right to it? What's the inaction on their part?
Well, when it comes to inaction, it's a little bit of a strange situation where iodice doesn't exactly correlate here, because here we believe that the town did take the affirmative action of interjecting themselves and giving these specific instructions to say, okay, you need to do A, B, C, D, and E in order to bring the
Doesn't the
facility.
record show, though, that special provision that applies to this type of an establishment did not, the code enforcement officer didn't know about that until well after he issued the certificate of compliance?
Well, certainly, but here That's
That's the problem.
important, right, Your Honor, and that's a very important point here, because we believe that where these very knowledgeable town officials, who it's their specific job to be learned in these specific topics when it comes to code compliance and fire protection, when they're going out and saying, okay, you need to do these specific things in order to bring the facility into compliance, I believe it would be my client's a small business. They are more than reasonable in saying, okay, in trusting those
I don't think
opinions
there's any
and relying
question.
on those.
I don't think there's any question that the code officer made an error here.
Certainly.
He did. And he told you one thing, and then a few months later, he learned, oh, he added another requirement on. But in order for you to prevail, I mean, with the governmental function and the immunities that's attached to the government, you have to get over certain hurdles. That's what I'm driving at.
Right, Judge. So I think with that second.
Not an ordinary negligence case.
I think where that second prong comes into play in this type of situation, it's, okay, they made these instructions. And of course, and in this sort of situation, that second prong, I believe, is my interpretation of that at least is, would those town officials have knowledge that if they did not give correct instructions that my client's a small business would rely on those representations?
Yeah, see, that's where I think I have a problem with the fourth factor, justifiable reliance. The way it seems to be framed in your brief is that, but for this mistake by the code enforcement officer, your client would have been saved a lot of time, money, effort in building this laser tag facility. But the facts, as your client even lays them out, he got his building permit on July 31st of 2013, got the building permit. Up until that point, there had been no misrepresentations about what he needed for fire protection or anything. He got his C of O August 12th, 13 days later. The allegation is that sometime between those two dates, those 13 days, the fire chief came in along with the code enforcement officer. They said, look, you got to do some things. There's some things hanging from the ceilings that you got to take down for the sprinklers. And they told them to do a few things. Now, there's no allegation that any of those things weren't required ultimately. What they didn't tell him is, by the way, you got to get this other thing that's really expensive. They found that out later. So the reliance, everything, the lease, your client got the lease at the Finger Lakes Mall. Your client built up the wood and set up the whole laser tag situations. Your client did everything for the C of O. If there's any reliance, I don't see anything that they did in reliance on the failure to tell them about this fire code. It just seems to me all those expenses, time and effort, which is what the suit is all about, were expended anyways. Am I wrong?
Well, I believe so, Your Honor. I believe that this was a situation where.
Yeah, your argument is he wouldn't have done anything. He wouldn't have spent all the money on all these improvements from that point forward.
But there were no improvements at that point forward. He had already made, my point is that he made the improvements for the C of O. The misrepresentation came after he leased it, bought the wood, made all these improvements and spent everything. That's when the misrepresentation was made, after the C of O. Can you name one expense that was incurred after the misrepresentation?
Well, Your Honor, I believe the way everything took place was when this was, the code enforcement officer had started trying to contact my clients when they were still even in negotiations.
Right, but they had no discussion about the fire issues until after the C of O. That's right in the record, after July 31st. That's the first time this even came up. And now your client's trying to make it out like, oh, if you had told me before I needed this, I wouldn't have even leased it. I wouldn't have done anything. And that's just not factual.
In other words, silence.
Well, I'll stand corrected on that. I apologize, Your Honor. But what I do believe would have happened was they would, if they had known that this cost prohibitive fire protection system would have been required, they wouldn't have gone through the necessary work in order to make the corrections that they did make per the instructions of the fire chief and the
With
code
taking down
enforcement
the
office.
stuff in the ceilings, but is there any indication that that wasn't also going to be required? Those were necessary anyways, but in any event, I understand your point. I think you got problems on a lot of different fronts, but we'll certainly take a close look at it.
Okay, I think we have it.
Thank you, Your Honor.
Thank you. May it please the court, Brad Hunt from McKinsey Hughes for the town of Aurelius. I think, Justice Joseph, your question about the knowledge of whether inaction will lead to harm, and Justice Carnage, your question about what is the inaction, that's right on point in terms of how we apply this, the test that they're arguing for, which is whether there was a voluntary assumption of a duty. And in the cases that I'm aware of where this court has found that there has been a voluntary assumption of a duty under that test, they're very different from this situation because they're situations where the government has actually promised to do something and then not done it. Like the DeLong versus Erie County case was a promise to from a 911 dispatcher to send help to a particular address. They didn't do it. And similarly, there's another case we cited, Zibin versus Town of Cheektowaga, where the police represented that they would check on a particular house. They didn't. And
Yeah, it all
murders
derives
happened.
to these older cases. The older case, I think it was in the Bronx or downstate, where the police officer said, stay right here. And then that's a little bit a greater degree. There's a second department case too. It's a little bit older, from the early 2000s. That's right on point. But, and that was with, I think, a C of O. Town of Huntington may not be held liable for plaintiff damages for acts of its building inspector in erroneously issuing a building permit or the subsequent decision to revoke the permit.
Yeah, I think that sounds right to me. And the other point I was going to make is that the Barskys avoid, they're not arguing under the test that's governed by the Court of Appeals, Garrett versus Holiday Inn's decision, which is whether the government actively assumed direction and control of the situation in the face of known safety violations. And I mean, the reason they're not arguing for that is that there weren't known safety violations here. That's undisputed on the
Yeah, they're
record.
under the second, there's a couple, as Judge DeJoseph laid out.
Yeah.
They're under a couple prongs. My understanding is that the voluntary assumes a duty, justifiable reliance by the person, and then there's a 4-prong test.
That's right. And, I actually think that the question of actively assuming control is close to what the substance of what they're arguing, because they're arguing that, the town was actively involved in the process here. But under the Court of Appeals Garrett decision, the law is very clear. That's not a basis for liability unless the town was actively involved in assuming direction in the face of a known violation. That's the test, and they didn't know it here. I would also just note that I do think you're correct, Justice Lindley, that the work they were instructed to do was required. If you look at the special amusement building section of the building code, which is in the record, the very first thing it says is special amusement buildings are required to comply with these other regular regulations and this section. And there's not been an allegation here that they didn't need, to take the stuff off the ceiling that was blocking the sprinklers.
Yeah, to Justice Lindley's point, in other words, all the work was done before.
The reliance here, as I understand their argument, occurred exactly, in the period that Judge Lindley identified, when between the issuance of the building permit, which was perfectly appropriate in itself, this was an appropriate location for a laser tag facility. They just needed to comply with the fire requirements. So between the issuance of the building permit on July 31st and, the issuance of the certificate of occupancy in August, that's the period when they were working with the town to try to get compliant. So, and the only other point I would make, as I stated in my brief, I do think that imposing liability on a town in this kind of situation has harmful practical effects. Because basically, the town's position is, the plaintiff's position is, the town could have refused to communicate, refused to meet them, refused to give any sort of guidance, just stayed home. Then I showed up for an inspection, erroneously granted a certificate of occupancy as they did, and then later revoked it upon learning of the mistake, and the town would be fine.
I don't know if that's your best argument. That's not, an argument for good government.
I think the importance, I think it's important for good governance to encourage town code
Of course,
enforcement
that's what
officers
they're there to help people.
to try to help people.
Yeah.
And also to when they, on the rare occasions when they do make mistakes like this, to go ahead and correct them and, revoke certificates of
Right,
occupancy if
you don't
necessary
want,
for public safety.
you don't want us to create an incentive for government officials like building code officials to not try to be helpful.
That's exactly right. My experience working with code enforcement officers is the good ones, communicate with applicants and work with them to try to figure stuff out. And sometimes it's a learning process for everyone involved, but we want to encourage that to happen.
Sure.
Thank
Okay.
you.
Thank you. (10:09) Founders Pavilion versus Pavilion Operations.
May it please the court, Amy Shapiro.
Hang on one second, Ms. Shapiro. I know you can't see, but opposing counsel is still getting situated.
Now I can, sorry.
Okay. Okay, you're all set, Counselor?
Thank you. May it please the court. Amy Shapiro, Hinman, Howard, and Patel, representing the appellant Pavilion Operations. In this case, my client bought.
Let me see if I can help you out, not to just cut you right off, and then we'll let you carry it from there. As I understand it, can you hear me okay, Ms.
Yes,
Shapiro?
Yes.
Okay. That the argument is that the plaintiff failed to meet their burden to establish the amount of the settlement that was attributable to the pre-closing rate appeals, or at least, at the very least, is a question of fact. Because in your view, right? Am I on the right page?
Yes. Okay.
Because in your view, a portion of the settlement must be attributed to the forward-looking claims, because those were waived, and there must have been some money that was attributed to this mitigation effort to negate the impact of this new reimbursement methodology. Is that right?
Yes, Your Honor, correct.
Okay, so tell us why.
The why.
The documents that support that position.
The court here was required to interpret the asset purchase agreement by the parties. The asset purchase agreement has a watershed moment. It says if third-party lump settlements, and we're talking about the state universal settlement payment, a third-party lump settlement payments, if they are for periods before June 1st, 2012, or arise from services rendered before June 1st, 2012, they belong to the respondent. If not, if they're after June 1st, 2012, they belong to my client.
All right, so can I ask you this, where, it seems to turn on the universal settlement agreement from 2015. Was that backward-looking only? Thank you.
No, you're.
Was it, because we know it was backward-looking in part, because the whole idea was you had claims under the pre-rate change in 2012, they had disputes. They gave those up, nursing home gave up those claims that were owed more money in response for the settlement. But it sounds like what you're saying is that that was only part of the universal settlement agreement. Some of the money went to that. Some of the money went to the current nursing home operators to offset losses that they incurred or things that they gave up. But where exactly in the universal settlement agreement, is there any allocation in that agreement of how much went for backwards and how much went for forwards?
Let me, I hear two questions. Let me address them very briefly. You asked where it appears in the universal settlement agreement that future rights are waived. Just to make that clear, sections 1.1 and 1.2, subdivisions 2, 4, 5, 6, and 7 contain the waivers of future rights. There are a variety of rights to challenge the way the state calculates Medicaid payment. For instance, does it get inflation correctly to rebase the rights? For instance, is the global Medicaid cap correct? That can't be challenged. Another thing that can't be challenged are different payments to different parts of the state to reflect different wages. It's clear wages here in Rochester or Binghamton are quite different than Manhattan. Medicaid is adjusted to reflect that, but we don't have the right anymore to sue to claim we think they got it wrong.
So even, let's say there was a nursing home that was created after June 1st, 2012, new one. They still get money under this universal settlement agreement?
Yes, there's evidence in the record that a nursing home a signer of the universal settlement agreement did not have to have rate appeals pending in order to be part of the agreement. And indeed, there's evidence that everybody who signed, every facility that signed got $250,000 or 5% of its Medicaid income, I believe, on a yearly basis. So it's crystal clear that the agreement itself makes no allocations for time periods. And the reason was the state just didn't want to mess with that. The state said, we'll assign a settlement amount to the facility. And if there's been a change of ownership, you folks work it out privately. And in fact, in order to get the money, the party that's claiming the entitlement to the proceeds has to sign a document saying that it has an agreement regarding how they are to be shared with the former owner or a current owner.
So you say that there's issues of fact, that there should be a hearing or a trial to determine what portion of the $664,294 was for the rate adjustments prior to 2012 that would go to the founders, and how much of the rest would go to your client. When the state writes these checks, is there any delineation of how it's allocated?
No, none whatsoever. And indeed, another facility emailed the Department of Health, and they asked what would be a very logical question. They said, please give us the rate appeal amounts for each institution under the Universal Settlement Agreement. And if the court were right that the only purpose of these settlements was to settle the rate appeals, the state would have that information, because otherwise, how would it be deciding how to distribute the total pot among the facilities? But the answer of the senior attorney of the Department of Health is, and I quote, page 324 of the record, rate appeal impact calculations do not exist. The state never calculated that. And then the email goes on to explain that the reason is the Department of Health was looking for a way to smooth the impact of the transition to the new pricing and to help groups that were hit harder than others. The fact is the universal settlement was universal. It settled the administrative backlog of claims, such as the backlog of administrative appeals, such as what the respondent had. It also settled dozens of proceedings and an enormous amount of litigation, but it also was intended to ease the state's transition to a whole new pricing method that it started as of June 1st, 2012.
Counselor, let's, if we could, I don't mean to interrupt you, but you've got to be cognizant of your time. I'd like to hear, the second point. In other words, you say the court erred in granting the plaintiff's motion and denying your motion relative to the responsibility to repay the overpayments. So why don't you spend a little time on that, please?
Yes. Medicaid calculations are complex, but one of the elements that Medicaid tries to reflect is to in some way reimburse the nursing facility for its costs. And the way Medicaid knows what those costs are is on the basis of cost reports. The cost reports then are the basis of Medicaid paid 2 years later. And
Let me ask you this may have nothing to do with it, but let me ask you this. Is this where they come up with their numbers when you go into a skilled nursing facility and they have the average cost of care in various regions of the state? Does this have to do with that?
Your Honor, I don't believe so. And I'm sorry, I can't actually answer your question. I believe that the cost reports are designed to capture the cost of exactly this facility, your investment, your taxes, your insurance.
Yeah, your argument is that the reason that your client's responsible, or the reason that there are payments to be made back are caused by the seller because of what they did in the previous 2 years when they sent inaccurate cost reports for the 2 years prior. And that's what the analysis was for the future.
Correct, Your Honor. It is complicated. What we say is that the only criteria was, did the appellant prepare these cost reports? Yes, they did. On the basis of the cost reports, Medicaid was paid 2 years later. And then several years later after that, in 6 and 7 years later, Medicaid finally finishes its audits of the cost reports for 2010 and 11 and says, uh-oh, there were problems.
Right. I understand it. We understand that you say that the overpayments, that the Medicaid rates were inflated based on bad inaccurate, inflated cost reports that the founders had done in the past before you guys got there. But isn't the relevant, so that explains why the overpayments were made, but isn't the relevant inquiry is who got the overpayments? And if your client got the overpayments, shouldn't they have to give them back?
No, Your Honor, they had to give them back to the state, and they did give them back to the state. That squared away things with the state. But as between us and people we bought the property from, the APA makes clear that we're entitled to the benefit of our bargain. And like any other commercial.
Justice Lidley's point is you were the beneficiary of it, so why wouldn't you have to, give it back? And as I understand your argument, that under this provision of acts or omissions, that it was the plaintiff's acts that caused this, and it doesn't matter if, possibly you get a windfall. I know you probably say you don't get a windfall, but.
I understand your point. We gave the money, it's correct. The state was entitled to recover money from us that we got, and it did recover that money. However, we are entitled to recover that back from the seller. And the reason is that in the APA, they agreed to that.
Right, and we're only dealing with 110,000. They acknowledge that the other 55,000 is their responsibility.
Correct, Your Honor. That's right.
But what Justice Carney, said is true, and maybe that's what dictated by the agreement. But your client would be getting a windfall of 110 grand because you got overpaid, and the state overpaid you, but it was the founder's fault. So you get to keep the money.
Yes, Your Honor, that is our position. And the reason is, I'd like to go back a bit. When people buy and sell,
I don't want to argue for you, but I would assume your point is that your costs were accurate. And if the plaintiff, provided the accurate costs, then there would be no requirement to pay back. But more importantly, that's the deal that they cut. And pursuant to the asset purchase agreement, that's what it says, and we should interpret it accordingly.
Thank you. And I would further say that the respondents' briefs say, well, we should have known through our due diligence that there were problems with the cost reports, and we should have adjusted the price accordingly. The response to that is that the Court of Appeals has said that due diligence isn't measured by hindsight and Monday morning quarterbacking. The DDJ management case says the question is whether you've acted reasonably. And then very importantly, it says if if you receive a representation and warranty that something's true, part of the due diligence analysis is that you're entitled to rely on that.
Okay,
So-
I think we understand. I think we understand your arguments.
Thank you. If there are no further questions, would you like me to return to the universal settlement portion of this, or are there no further questions?
I'm all set with my question on the settlement, but
I'm
all set too.
Oh, okay. Thank you, Your Honor.
Counselor?
Good afternoon. May it please the court. James Nankas for the respondent. It sounds like your honors have a very good read on the asset purchase agreement and that it allocates assets and liabilities on the effective date. So I won't go through that background. If it's okay with your honors, I will just jump right into the issue on the universal settlement agreement. How do you reconcile allocating all the money to the past issues if there are these forward-looking provisions? First, I'd start with the actual language. If you read the universal settlement agreement, the reference to the money comes right off the bat and references to get to settle out the old matters. And what the state was doing was clearing the backlog of the old stuff because it wanted to move into the future. And so to get rid of that, if we think of it like a settlement agreements for a personal injury action or breach of contract, the one side will pay the other side, and then there'll be forward-looking provisions. There'll be certain things like a non-disparagement clause or a non-disclosure. Those provisions carry forward. But I submit, your honors, it would be illogical to say, to start looking, let's splice up what the settlement payment was for. Was it for the underlying breach of contract, or was part of it for that non-disparagement? I just think, especially since our asset purchase agreement gives us the right to funds arising from pre-effective date services.
So
we're the only ones
looking.
I'm sorry, Your Honor.
In other words, you want us to look at 1.2.10 and 5.6 as well as the settlement agreement, and you say it's unambiguous.
I do submit the settlement agreement is unambiguous, Your Honor.
And how much money are we talking about here?
600 and one moment, Your Honor.
664.
Yeah, right. So what,
640.
and there's another $1 million still in escrow? I'm just curious about that.
Oh, let me walk through the escrow agreement, Your Honor. I'm sorry. It gets confusing because think of it as two different accounts. There's the universal.
No, I realize that, but why is all this money all locked up for all this time when the claims only, they're not that great?
Well,
It's 654 plus 110, isn't it?
Well, the $1 million that was locked up, and trust me, we tried to work with the other side to get a lot of it released. That is actually only the OMIG piece. So we're only.
I'm sorry, say that again?
That is only only the OMIG piece, actually, Your Honor. So there's only, out of that $1 million, there's only $166,000 in dispute.
Well, it's not even in dispute. You agree that 55 is your responsibility.
I do, Your Honor. And once we got the order from Judge Wiggins, thankfully, the other side finally got to work around with us to get to release a lot
I didn't
of
mean
it.
to break your stride. I just was curious.
I'm sorry, Your Honor.
Can I ask you this though?
I didn't mean to break your stride.
Oh, no. I'm happy to answer Your Honor's question.
Your argument is that the 664, 294 is all for rate adjustments. So you gave up your right to litigate. You thought you were shorted prior to the rate adjustment 2012. And that this universal settlement agreement that was 100% dedicated to resolving those claims. Ms. Shapiro, that's your argument, right?
Your Honor, if I may just tweak that for a second.
Sure.
We gave up the appeals we actually had pending under the old reimbursement methodology, and we also gave up the right to bring any additional appeals down the road. You waived all your rights under the old methodology, and the state did not do a case-by-case. It threw money at this issue to make the past go away.
Right.
Sorry, Your Honor.
But she points out, if the universal settlement agreement was to settle pre-2012 claims that you had, your claims were half of what you ended up getting. You got 664. She claims that your total rate, if you won every one of your claims, you would have gotten about half of that. So she says logic dictates that the proceeds were not exclusively for settled rate appeals, contrary to what Judge Wiggins held.
Your Honor, if I may address that, that estimate of the value of those appeals was our own estimate. We also gave up in the universal settlement agreement the right to bring any other appeals. But let me stress this, Your Honor.
The state, at the end of the day, issued these funds to clear the past. The state did not sort of determine, okay, they have exactly the state's object was to avoid all of that, Your Honor.
They were just ballparking it?
I'm sorry.
They were just ballparking it? Because they were like.
No, so the state issued the funds to the working group, and the working group essentially came up with the task of allocating, and trust me, there were in the beginning all sorts of discussions about how this should allocate. Should we try and smooth things in the future? No one could agree on anything. It all went away. The state said, here's the money. We just want the past issues to go away. And then the working group issued the funds and allocated it to get, every home had to come on board. So $644,000 went to this facility. But if I may, Your Honor, as I talked about, there was a settlement agreement. You know, in a normal settlement agreement, you'll have all these forward-looking provisions. That doesn't mean money's allocated to them. And I'd like to point the court to the Bainbridge decision, which has been cited by both parties on this appeal. Bainbridge is a case where it actually looks at one of these forward-looking provisions.
Yeah, and all it does is limit the ability to bring the lawsuit, and you know, it doesn't. In other words, all it does is limit the ability to how fast you get it done.
Your Honor, exactly. Under the new methodology, you may of course bring appeals. The buyer here.
You're not waiving your right to bring new appeals.
No, and Your Honor, I might just add for the record that the moratorium on litigation to force faster decisions has actually been lifted now. So litigations are now commencing in full on rate appeals. But even in the context of looking at one of those forward-looking provisions, the court made clear, and I'll just quote it real quickly, Your Honor. The state in turn sought to settle all claims relating to the prior reimbursement methodology in exchange for paying no more than $850 million over a multi-year period. Even faced with the fact that directly at issue in the case was whether one of these forward-looking sort of limitations, if you will, was at issue, the court went out of its way to say, here's what the settlement money was for. It was for the past stuff. There are some forward-looking conditions. Your Honor, it would be a question of fact that I think we don't need to go anywhere near, but I would like to point out that there's evidence in the record that these forward-looking provisions really.
Yeah, that's a different issue.
Correct, Your Honor. I submit
if there is a question of fact, I don't know how that's going to be.
Exactly, correct, Your Honor.
Would the question of fact, if it went to trial as Mr. Pirro wants, would the question of fact, would they have to call people who were involved in the settlement agreement who negotiated the?
Your Honor,
those are the only people who know the answer, right? I mean, the question is, what did the settlement agreement pay for? Just past or also future? The only witnesses who would you call?
Or to Justice Lindley's point, that you only thought you had, or opposing counsel, I should say, is you were only making a claim of about half of that.
Your Honor, that was the estimate of our claims. Yeah. But I think Your Honors are exactly right. I was wondering what a trial would look like. Do we call the governor to say, you know, what? I submit, Your Honors, what we should do is instead turn to the settlement agreement itself, which is the $850 million. Is for the settlement of the past stuff. It does have some forward-looking
your point is it's unambiguous, and we don't need to go any further than that.
Correct, Your Honor. And I would submit that the Chief Judge of the Southern District of New York dealt exactly with these issues with a former owner and a current owner. She cut right through it all and said, current owner, you didn't own it during the old reimbursement methodology. I'm cutting through this. You get no money. That's exactly what should happen here. They bought this facility knowing full well the new methodology was in place. They bought the facility for a price they were comfortable with, knowing that methodology. For them to try and reach back and get money that's out is to settle matters under the old methodology when the state was just trying to clear the deck of that stuff would be a windfall, Your Honor.
Okay, I think we understand. Anything else?
Could I jump? I'm sorry. Could I jump into the OMIG issue, Your Honor?
The what issue?
The second issue, which is that OMIG issue.
Yeah.
And I think Your Honors have that issue correct. At least as I understand some of the questions, I think it's the exact right question to ask, which is why should the seller be responsible for paying overpayments that were received during the buyer's operation? The cost report argument, may be interesting enough on its face, But the asset purchase agreement says, it specifically says you can't raise this argument a year after the purchase. Now, Ms. Shapiro talked about, well, argument about due diligence, pre-closing. But let's think about that 1-year rule for a second. Essentially, the transaction closed. They get to operate for a year. They have all the records. They know exactly what's in these cost reports. They were on board with them. The asset purchase agreement has that year rule to prevent this kind of looking backwards. And I would just submit, Your Honor, a lot of times with these cost reports too, there's not misstatements or anything like that. It's the office, the OMIG office basically will look at and make judgment calls on, well, you submitted this as a capital improvement, but we think it was actually routine maintenance. So there's always going to be some judgment calls there. I just submit that the asset purchase agreement here should control, and it clearly bars these claims from being made. I leave aside all the other arguments that are in our brief, but I think that's just the focus here, Your Honors.
Okay, thank you. 1010, Laniski versus Jagar, at Joseph Barra Driving School.
Are we set to go here? Have I connected?
I don't know if we have Ms. Brown.
Okay.
Oh, I'm here. Can you guys?
Okay, we see you now. Great.
Okay, thank you. Sorry about that.
Okay, proceed, please.
Good afternoon, Your Honors, and may it please the court. My name is Jason Telak. I represent the plaintiff, Julie Wisniewski, and it's our position that in granting the defendant's motion for summary judgment, the trial court here either failed to consider the plaintiff's deposition testimony or failed to view it in the light most favorable to the plaintiff as the non-moving party. The plaintiff here was a passenger in the rear-ending vehicle. She was an eyewitness to the collision. She testified during her deposition testimony about her direct observations of the collision. And she testified that the lead vehicle came to a sudden and abrupt halt completely within the right lane of travel. And the trailing vehicle in which she was a passenger was unable to stop in time to avoid the collision.
But isn't the issue whether that the lead vehicle stopped in response to the emergency vehicles under the V&T law had a duty to pull over and stop? And they're saying that was an explained, well, first of all, they dispute that it was sudden and abrupt. The driving instructor said that she told Mr. Mara to turn on his signal and he came to a slow to moderate stop. But let's assume that it was abrupt. There was, is not what you're supposed to do in response to an emergency vehicle is pull over to the right and stop.
Well, that's correct, Your Honor, that vehicle and traffic law does require drivers to pull to the right side of the road and bring their vehicle to a stop. And our point is that vehicle and traffic law says bring your vehicle to a stop, but it doesn't excuse the sudden or abrupt nature of the stop that the plaintiff testified to in this case. The plaintiff's testimony was clear that the vehicle ahead came to a sudden and abrupt stop directly in the right lane of travel. And although vehicle and traffic law does put a requirement in place to pull over and bring your vehicle to a stop, it's our position that that stop still needed to be done in a reasonable manner, that it can't be sudden, it can't be abrupt. And there's no case law that I'm aware of that says that when confronted with an emergency vehicle, a driver is allowed to bring his or her vehicle to a sudden and abrupt stop right in the lane of travel, which is what the plaintiff testified to in this case. And, you know, in support of their motion for summary judgment, the defendants did cite a few different cases involving emergency vehicles approaching. And in those cases, you know, basically the essence of the opinion was that the vehicles in those cases had to come to a sudden and abrupt stop. Most of them involve situations where an emergency vehicle was approaching at an intersection, and to be out of the way of the emergency vehicle, you know, the lead vehicle had to come to a sudden and abrupt stop, and then it was rear-ended from behind. That's not the factual situation that we had here in this case. This rear-end accident happened on a multiple lane roadway. The emergency vehicles in question were approaching from the opposite direction on the opposite side of the roadway. There was no
Does that make a difference? Does that make a difference?
I think that it does make a difference in viewing the reasonableness of the conduct of the lead vehicle in coming to an abrupt stop. And I think it all needs to be viewed, you know, in light of all the circumstances and judging the reasonableness of the lead vehicle's actions in bringing the vehicle to an abrupt stop in the lane of travel. And it's really a question that should be decided by a jury rather than by a judge on a motion for summary judgment, because it does deal with the reasonableness of that, you know, the lead vehicle's actions.
So I think we've got your arguments. Thank you.
Okay, thank you. Can I just touch on one other thing? It's pointed out in the brief, but you know, there can be more than one proximate cause to a rear end motor vehicle accident. We cited several cases that say that. And the fact that, I'm sorry, Your Honor?
We understand those principles.
Okay.
Go ahead.
I will rest on the papers unless there are any other questions for me.
Okay, thank you. Ms. Brown?
Good afternoon. May it please the court. Everyone can hear me, hopefully. All right. I represent the respondents, Mr. Mara and the Stevens Driving School. Just briefly, because I think everything's been adequately briefed by both sides, but turning with respect to the issue of the stopping for the emergency vehicle, the language of Vehicle and Traffic Law Section 1144A requires that the drivers pull over and stop immediately. So that is the basis for the alleged abrupt stop. And the case I would direct you to is Barton versus Humans. It's cited in our brief. It's a decision from this court. It's not addressed in the appellant's reply brief, but in that case, this court held, I'm sorry, is there a question there? That the driver had to stop abruptly. Oh, I'm sorry.
No, go ahead. I'm sorry. You go ahead.
I apologize. Gotta love this technology. In the Barton case.
It's difficult. I was going to say that we're familiar with that case, and that's the case that the Barton case stands for the proposition that although an abrupt stop can be sufficient to raise an issue of fact, here the plaintiff stopped abruptly to yield an emergency vehicle pursuant to 1144. So you're suggesting that even assuming arguendo it was, you know, if there was an abrupt stop here, it was proper and it was required under the Vehicle and Traffic Law.
Exactly. And I would just say with respect to where he was stopped in the roadway, the photographs are in the record. There's no shoulder. The statute requires pulling over as far to the right, you know, as possible, which no one claims he didn't do that. In fact, Mr. Jaeger, who was driving the rear vehicle, was attempting to do the exact same thing when the accident happened. The only other point I would make.
Okay, I think we understand.
Okay, just briefly, Your Honor, with respect to Mr. Tilak didn't really get into it, but we're saying there was not even an abrupt stop here because it was incumbent on the driver of the rear vehicle to offer the non-negligent explanation for the collision. And that's the wording in all of the cases that we've cited at page 11 of our brief, including about half a dozen from this court. And so based on that, it's our position that the plaintiff.
Yeah, I know we've said that, in the past, but it seems like really what we got to do is focus on what the lead vehicle was doing. Maybe the same analysis, but,
Sure. Yeah, exactly. And so to that point, Your Honor, then I would say even if there is an abrupt stop, it was not negligent because of the need to stop for the emergency vehicle. And with that, I'll rest on my brief.
okay, thank you.
Thank you.
1011 Harrington versus the City of Oswego. Okay, good afternoon.
Good afternoon. May it please the court. My name is Amy Chadwick. I'm appearing on behalf of William Harrington. What we have before us is an Article 878 petition that was dismissed. It's our position that it was improperly dismissed for a number of different reasons. First and foremost, it was dismissed on grounds that were not actually raised in the motion to dismiss. The city sought dismissal on two separate grounds, lack of subject matter jurisdiction and release. Neither of those were mentioned in the court's decision in dismissing the petition, but rather it was dismissed.
Counselor, excuse me. It appears from the court's decision, right, that the court took a more global approach to analyzing the stipulation of settlement, correct?
Yes, I believe that is
Could that
correct.
global approach include the release?
Well, the actual decision from the judge does not discuss the release at all. Rather, it focuses on the judge's decision that the terms of this agreement controlled what Mr. Harrington's health insurance benefits would be, and that's not an issue that was raised in the motion to dismiss, and certainly wasn't an issue that Mr. Harrington had the ability to adequately brief in his memorandum opposing the motion. And if there had, we have a number of arguments that I do raise in our papers here as to why, other reasons that we would have argued against the court's interpretation, but we didn't have that opportunity to do that because those were not.
As I understand your argument, excuse me again, as I understand your argument on the release, you target the release, you say that the release is targeted to the disciplinary proceeding. And if I read the city's brief correctly, they say it's to employment and retirement as well. So we really have to look at the terms of the release. Wouldn't you say, to kind of dig down to say which one we agree with?
I would say so, certainly. And there are two separate paragraphs that do address the release. But also at the end of the day, the judge didn't actually discuss the release or make a decision on the release section of it. But there are two paragraphs addressing release. One is a more general paragraph, which is saying that he's releasing all claims arising out of the facts and circumstances of the above referenced matter. Well, this is a stipulation regarding a discipline matter. So it's certainly our position. And if we're looking at it in the light most favorable to Mr. Harrington.
I think that was my question, really.
Yeah.
And the parties have teed it up quite nicely for us to look at that release and say, is it limited to the disciplinary matter or is it more broad than that? On that issue, in terms of release, that's what our court has to look at, right? On that issue?
I think that is certainly one of the issues that does need to be looked at. And of course, it's our position that
What was the consideration that your client gave up?
Well, he was
in this proceeding. What did he give up, if anything?
Well, he had a right to challenge the disciplinary matters that were brought against him. He could have had a hearing if he had any defenses or claims against the city. He could have brought those as well. So by releasing,
part of that was he agreeing to retire?
Yes, part of that was he was agreeing to retire.
So why isn't this agreement worked into that? In other words, if he just retired otherwise, right? If he just said, I want to retire today, he wouldn't get the benefits of this subsequent amendment to the CBA.
Well, I do believe that if he had just retired, he certainly would still have had an argument that he would have been entitled to the benefits of the amended CBA. The CBA that was passed before he retired. It's certainly retroactive to 2017, so covers the last 2 years that he was employed. And there's nothing in the.
I thought the buyback didn't come into place until February of the subsequent year.
It was added in February of 2019, but there's nothing in that indicating that it's only going forward. It's being, in addition to the collective bargaining agreement that goes back to 2017, and there's nothing in it saying that it would not apply to him. And really, when you read the terms of the stipulation, they're really just restating what his benefit rights are. They're not, giving him a new or different kind of a right. They're just restating the right that he would have had anyway, because the main focus of that was the discipline.
Okay, thank you.
And with regard to the question of subject matter jurisdiction, the general rule, of course, is that you
on that issue, that has to do with administrative remedies, correct?
Yes, yes, Your Honor.
And you notice that was the city's first argument below, and it's the third argument here, right?
Yes, I do.
Is that telling to you?
It is, and just as my papers say, I think that we've briefed it adequately there, that he did not need to use that procedure. It wasn't even available to him.
Thank you.
Yes. If you have no further questions, I'll rest on my papers.
All set. Thank you.
Thank you.
Good afternoon, and may it please the court. As Counselor discussed, the issue here really comes down to the release language. The respondent submits that although the release may not have been referred to specifically in the decision, that it's clear from the nature of the decision below that it was based on the language of the stipulation and the release of any claims for any benefits outside of those that are specifically enumerated in that agreement. I think that it's clear from the court's decision that it considered the language of that agreement, which includes the release, and stated that the terms of the parties' written agreement very clearly address the rights that he has to retiree health insurance. Just to the same extent that.
Excuse me, Counselor, as I asked your colleague there for the other side, it really comes down to asking this court to look at that release language to say, is it broad enough to include this claim, correct?
Yeah, I believe that's certainly one of the central issues here. And it's our position, as it was at the court below, that the release language is broad. It refers to release of any claims, known or unknown, related to the subject matter of the agreement, which, I know that the position of the appellant is that that was limited to the disciplinary action, that he was releasing claims with respect to the disciplinary action. I think the plain language of the agreement demonstrates that the subject matter of that agreement was not limited to the disciplinary action. In fact, there's only 2 or 3 paragraphs of the agreement that refer to the disciplinary.
Just to fine tune that point, as I read your brief, you're saying, wait a second, look at the terminology of this release. It says the matters referenced herein or referenced above, whatever it is, all of which discuss retirement, the terms and benefits, et cetera. So you're saying it's not just relating to the disciplinary process, it relates to everything discussed above.
Correct. And as was illuminated from the questioning of the appellant, that includes a release of benefits with respect to retirement, his ability to retire, the benefits that he's owed upon retirement. I think it's very clear and unambiguous from the language of the agreement that his benefits in retirement, the terms of his retirement and things like that are included as subject matter of the agreement, and they are therefore covered by the release.
Okay.
I did want to. Oh, I'm sorry. I just very quickly I just wanted to respond, if I could, for just briefly to the appellant's commentary about their inability to sufficiently brief the matter with respect to the validity of the agreement. I would submit that that argument falls short, since they had full knowledge and were on full notice below in the motion to dismiss that the respondent was asserting that the terms of that agreement and the release included therein were the basis for the motion to dismiss. I think they had adequate opportunity at that point, if there was some question about the validity of that agreement, to raise that issue. And certainly that would have been relevant to the extent that the release is included in that agreement. And I did just want to make one note about one of those arguments that, as Ms. Chadwick notes, they raised for the first time in their papers here with respect to inequitable dealing in the execution of that agreement, and the allegation that the city knew when they entered that agreement that this subsequent February MOA may come into effect. And I would note that Mr. Harrington was attested in the agreement that he was fully represented by his union. And to the extent there was any ongoing negotiations for something different, his union would have been on full notice of those rights and could have advised him as to those rights at the time and said, hey, maybe we should include in this agreement that if it's changed, that if these benefits are changed subsequently, you'll be entitled to those changes. And the language of the agreement simply does not do that and does not refer to any amendment of the agreement based on subsequent amendments to the CBA.
Okay, thank you. 1012, matter of arbitration, City of Utica. Okay, are we all set?
We are. I love this. This is great.
Well, we're glad to see you. And you can proceed, please.
Thank you, Your Honors. Good afternoon. My name is Ronald Dunn. I'm the attorney for the union of the Utica firefighters, and I'm also the attorney for Mr. Fort here today. The case is really pretty narrow and fairly straightforward. It is not uncommon for when you have a due process case that the case arises with uncomfortable facts. I have uncomfortable facts here. Having said that, it is a basic principle of due process that in a discipline case, you can only be terminated for that which you're charged with. And it's pretty clear here that the only charge that remained in the city's charges is that my client damaged a pair of bunker pants. Whether you call it damage or destroyed, damaged a pair of bunker pants. And yet the arbitrator ruled that he's terminating my client because he sexually harassed the owner of the bunker plants. Those two things don't line up.
Couldn't it be that there's damage of the pants and sexual harassment as well?
There could be, Your Honor, and he was not charged with that, but there could be.
But he was charged with damaging the pants. And look, there's no, the evidence is overwhelming. I know your client didn't testify, but the evidence is, this is not a who done it or what did he do.
I'm not here to argue that because
I know.
I'm not here to argue that. I'm here.
We understand that. But
this is a case where he was charged with one thing. He responded fully and completely with what he was charged with.
Sir, Justice Lindley's asking a question, so please, I know that we've got some difficulties with this technology, but please try to keep that in mind. So,
right. Look, you lay it all out in your brief very well, that he was convicted of a charge that he was not charged with. He was convicted of doing something he wasn't charged with. They charged him with damaging property. The arbitrator found that he did something worse, sexual harassment, and that can't stand. And you laid all that out very well, and we understand that.
I can't make my argument, but more completely than that.
Right. And you're relying on Murphy, actually Murphy versus Murphy, or Murray versus Murphy.
Old law, it still happens to be quite good law. And
right. Okay, we'll take a look at it. I think we understand your contentions.
Thank you, Your Honor.
Thank you. Counselor?
Good afternoon, Your Honors. Catherine Hartnett appearing for the City of Utica, and may it please the court. Your Honor, appellant's reliance on Murray v. Murphy is misplaced. Murray v. Murphy showed that if the conduct discussed at the hearing, if the conduct proven or not proven at the hearing has no relation at all to the final decision, then there's a due process violation. In that case, those officers were charged with associating with a known criminal, having dealings in Brooklyn with a criminal, and also negligently conducting an investigation.
And they were found to have been guilty of corruption, and that was a bridge too far.
A bridge too far.
Opposing counsel is trying to argue here that within this decision, there was no finding of what he was charged of, and actually there was a finding of something he was not charged with. So maybe you should focus your arguments to that.
Absolutely, Your Honor. In this case, the city's case was proven before the arbitration started that he damaged those pants. That firefighter, the female firefighter, was never going to wear those pants again. They were damaged, and that was proven at the arbitration. What appellant seems to have a problem with is that the arbitrator, needing to make a decision about a penalty, had to take evidence about the effect of this property damage on the working environment for firefighters, and appropriately found that this firefighter, Mr. Fort, could not work with female firefighters, that the city could not take on the exposure of having this particular firefighter continuing to work in a firehouse environment where you're living with your coworkers, and be around female firefighters. And that was the appropriate decision to make in light of the evidence. This isn't a case where he was convicted, I guess you could say, of something that he wasn't charged with, but this is a case where the arbitrator had to carefully look at the import of his actions, at the manner in which he committed property damage, and arriving at the proper penalty, which he did in this
Well, let me ask you, was there evidence that he damaged the pants? I mean, I know he soiled the pants. He didn't rip them, can't they just be put in the wash, and are they actually damaged?
Your Honor, they were contaminated with another human being's body fluids, and I don't think that the city could go and ask that female firefighter to just wash those pants and wear them again.
All right, well, he was charged with intentionally damaging property, but in any event, I think your point is well taken. I mean, obviously, you can't expect her to wear it, but it sounded like the scope of the hearing, the arbitrator thought was going to be what the penalty was going to be. That's what sounds like everybody went into it thinking about. Nobody was thinking about the front end because the evidence was overwhelming.
Absolutely, Your Honor. And in fact, the arbitration was greatly delayed because Mr. Fort, through his attorneys, attempted to get the disciplinary records for another attorney prior to the repeal of Civil Rights Law 50A, that for a mitigation, for a case in mitigation regarding the penalty, that other firefighter's case also related to sexual misconduct. So they were completely aware of what the charges were and the penalty that was being sought, and the specific factual allegations that the city meant to prove at that arbitration. So I don't think that Mr. Fort and his attorneys can credibly make a case that there was a due process violation in this case.
Okay, thank you, Counselor.
Thank you.
1013, Mariani versus Wilson Central School District. Okay, good afternoon.
Good afternoon, Your Honors.
We appreciate your patience. It's been a long day.
I think we're the number on the docket you've been looking for all day.
Yeah. Okay, when you're ready, you can proceed, Counselor.
Thank you, Your Honor. May it please the court, my name is John Licata. I'm here on behalf of the claimant appellant, Teresa Mariani.
Sir, let me jump in right here. I mean, we all know that the delay here is relatively short. However, that does not suspend your obligation to make certain showing.
Correct.
I think you'd agree with that.
I do agree with that.
Your reasonable excuse, he talks about the seriousness of her injury that was not apparent right away.
Yes, Your Honor.
Do you offer any medical evidence to support that?
There was no medical evidence.
Could you get an affidavit from a doctor?
I attempted to get an affidavit from the doctor. I filed this I attempted to file this quickly so to foreshorten that time frame.
Saw that you did, something was in fact filed in the clerk's office, I think in May.
Yes, and in June and then in July. I think there were some issues regarding the electronic filing of the order to show cause. I believe there was some issue with Justice Spinello getting it to sign it. Once we got that ironed out, we promptly provided the order to show cause to the school district.
On the actual notice question, you rely, at least in part, on an allegation that an individual, I think John Hallow or Jar Halloran or something, a name.
Hollow, I believe.
Yeah, that he apparently communicated with the superintendent. Is there an affidavit from him?
No, there is no affidavit from him. This is something that she believes had happened. But again, as far as the notice, the primary reliance of notice for this district is, this is a small district.
And they were right there when it happened.
Everybody is on the same campus. And between the time, when she was injured, this is not a visitor to the school, but a bus driver.
Right.
Who then had a route of school children to take for this district. She fell, was injured, and went to an urgent care facility. So somebody had to then take her route.
Right.
She had gone out to the site where she fell, and there was an orange safety cone, as you recall, in the record.
There's a photograph of that in the record.
There's a photograph of the condition after she fell, which shows that the condition was there.
An
And
accumulation of some snow.
yeah, there was snow and there was ice, and there were footprints in the snow and ice, and this is first thing in the morning. And the other element is when they came back, the parking lot was paved or was plowed clear to the pavement. There's also in the affidavit from the superintendent, he admits to conducting an inquiry into it. That was the word he used, that there was an inquiry that
You would expect that he would have, knowing this and being pretty much right on the scene, that he would have unearthed all the facts that he needed.
Well, reading of this, how does he come to learn that she fell? Somebody had to have told the superintendent that somebody fell. Superintendent has a fiduciary obligation as a superintendent for the school district that if somebody falls, to either delegate or conduct an investigation himself. He also has, I think, just common decency. Somebody fell, how are they, would be the next question, for which the answer might be that person went to urgent care. The fact that she then returned to work the next day and continued to work is kind of what puts us in this. I think I'd referenced a catch-22 for somebody who is injured, but for which these injuries don't manifest within the 90 days.
Well, I mean, we see this a lot in automobile cases, with somebody that attempts to go back to work. The fact that they maybe work through a little pain really shouldn't be held against them.
I think she did everything she was supposed to do. She didn't question her doctors. Once it was clear, I think there was a delay in her diagnosis because workers' compensation delayed her diagnostic treatment. From her primary doctor after urgent care, if I can just say, urgent care told her it would take 6 to 8 weeks or so. She goes through that time frame. She's not better. She goes to her primary. He tries to get a diagnostic test. He's denied from comp. She then goes to an orthopedic surgeon, and ultimately after 90 days, she has a diagnosis of a herniated disc, for which is part of the case law that I've seen when there is medical records required, there's an extensive period of time after. I mean, we're talking 9 months, a year. I think it was 3 years in Diaz.
I see it.
Days.
As soon as she learns of this, she comes to your office, you file something within a day or two.
Yes, which is why I didn't have, I tried to get it in promptly to the court for notice as opposed to taking the time. Now, I imagine in retrospect, would I have been in a better position to track down those individuals and then provide those? Perhaps so, I certainly would, but I don't think the analysis would change in the sense that I believe we've demonstrated that there's a plausible argument that actual notice was received, which shifts the burden then to the school district, and the school district has not met their burden. I believe
the question of prejudice?
Well, that they have to show substantial prejudice, showing my age, a particularized showing of substantial prejudice, which hasn't been made under Newcomb, that they can't just provide pro forma arguments. I mean, saying that memories fade, I think it's unusual for an educator to say within 60 days, memories have faded. Meanwhile, we're going to test kids on what they've learned 9 months ago or last year as well. So this memory fading, there has to be a demonstration of witnesses unavailable. I think Hersala was one of the cases we cited. Witnesses are there. This entity is in possession of the employees who were there at the time. Did they conduct their own investigation? Were there photographs taken? All of those questions, that's information in their possession. I
think we've got it. Counselor? May I please?
I have one simple question for you. Tell me how you were prejudiced by this very short delay.
Well, Your Honor, I think there's a couple ways to address that. One is the fact that, of course, we have an affidavit from the superintendent that, you know, they weren't on notice of an actual claim. All he knew was that someone slipped. They didn't do interviews.
If this notice of claim were served on you on the 89th day, how would you be in any different position then than you are now?
Well, and to address the point of memories fading and things like that, you know, the notion of that a janitorial guy in Buffalo or Rochester remembers every day back 3 months before. I mean, our winters kind of blend together.
Okay, but we are talking about a delay of I think it's 49 days.
Beyond the 90.
I think it's about 6 or 7 weeks.
Yeah, it's in that ballpark. And the other part of it, I think, Judge, is that here we have a situation where the claimant or the proposed claimant says her circumstances changed, it got worse over time. So the fact that we weren't able to do any type of medical examination pursuant to 50H.
You could still do that.
We could, but now of course she's had, it's not all, I don't know if this is in the record, but she's now had surgery, and we're now very different than when if we could have evaluated the causality before all these things. Now we're down the rabbit hole.
Well, if
she's had surgery.
If she served this on the 89th day, when would you have done your medical examination?
Presumably rather promptly if we found out there was a situation where the injuries are progressing rather rapidly. You know, and if I could dovetail back to, as far as the reasonable excuse, the claimant's own affidavit in support of the motion, I think it's
what's our standard of review here?
It's abuse of discretion under Rose versus Rochester Housing Authority, which is a decision of this court from 2008. So I think when you look at the factors, including, I think the lack of, and again, the burden is on the claimant to meet, you know, to show that we had no actual knowledge, to explain their excuse and to show the absence of a prejudice. And here they talk about this Ruthie C, who's not our employee. They basically say, well, it got shoveled and you know, this is Buffalo, Western New York. We're going to clear out snow. It's not going to sit there for 6 months. You are going to clean that up. It's not, doesn't mean we knew that there was a potential claim. We have the superintendent's affidavit, which is in proper evidentiary form, that says we weren't on notice of a claim. We didn't know that it was coming here. And then you go to I think the excuse arguments for the explanation. Ignorance of the law is not sufficient. The courts have held that over and over. And that's essentially the claim, is that she was ignorant of the law, and that's not enough. She also, in fairness, says, well, my condition was getting worse. But by her own affidavit, she had pain from the time of the accident on February 13th up to early April. She's having worse pain. Now it's radiating and there's numbness, I think, in her hands. So the pain is getting worse. She's got new symptoms. She then contacts her own doctor. The doctor wants to do tests. It sounds like there was some issues with comp, but obviously she's in pain and it's getting worse. It's not getting better. Ultimately, she gets diagnosed with a hernia.
You can get all those medical records. I mean, this is not uncommon.
And I can only go by what they put in the record, which was an affidavit from the claimant. I don't have medical records.
Well, I mean, you can get them if this case were to proceed, obviously.
If it were to, of course, but in characterizing the delay, she's clearly aware that she has some significant pain with increasing symptoms. And I'm not sure where the May date comes in, but I know that this wasn't ultimately presented to Justice Boniello until the 2nd of June, which is almost, and then served on my client on July 2nd and July 10th, which is now another 2 months beyond when she talked to lawyers. She is told she has a herniated disc. She knows all these things, and we don't get any notice, not a letter or anything else, until that time. So there's a further delay here.
I hear you. Okay.
Okay, we think we have it. Thank you.
Thank you, Your Honors.
Thank you.
Court is recessed.